Good morning, everyone. I call the Senate out of recess and call the Senate to order and recognize Senator Carson for a motion.
Thank you, Mr. President. I move that the Senate adjourn from the late session.
All in favor, please say aye. Aye. Any opposed? The ayes have it. We are now in the early session. The Senate will please be attentive to our chaplain, the Reverend Mark Warren. Good morning, sir.
President Bradley, thank you. Senators, good morning. Let's pray. God, creator of heaven and earth, you are the first lawmaker giving good and just laws to prosper humanity. Let us consider your law as our senators deliberate and form laws for the people of New Hampshire. In a world that is increasingly complex, we need your wisdom. Your Holy Scripture says that if we ask for wisdom, you are faithful to give it generously. Fill each senator today with your wisdom as they ask. Today we honor our senators as public servants, asking you to bless them and prosper their families. We're grateful for each person here today, from our clerk to our Sergeant-at-Arms, support staff. Bless them, I pray. It's in your holy name we pray. Amen.
Thank you very much. Maybe our friends could lead us in the Pledge of Allegiance. Thank you very much. Senator Perkins, Kwoka, is excused for the day. Now, introduction of guests. So we're going to start with Senator Lang.
Mr. President, thank you. I introduced the fourth grade class from St. Bonnie here in my hometown of Sanborn, New Hampshire.
Thank you very much for being here. Enjoy your day in the State House.
Thank you,
Senator Prentiss, you have some very special guests, too.
Yes, I do. Thank you, Mr. President. I'd like to welcome to our chamber this morning our guests, Captains Vicki Blanchard from the New Hampshire Division of Fire Standards and Training and Emergency Medical Services, and Captain Kathleen Doolin also from the Division of Fire Standards and Training and Emergency Medical Services. If I may, Mr. President, could we maybe move them a little bit so their families could see them while I say a little bit about their work, as both of these valued captains in state and public service are retiring. Okay, and I'd like to thank Senator Innes and Senator Ward for joining me in the resolutions that will be presented to them today. I've known you guys for so long, I'm all right. So, Captain Kathleen Doolin, Sununu, New Hampshire, serving the Granite State for 39 years in EMS, 31 as a state employee at the Division of Fire Training and Emergency Medical Services. Kathy was, and really is, a jack of all trades: licensing, education, compliance. She's also an advanced EMT and has kept her national certification up so she can continue to serve after she retires as a volunteer if she so chooses. No matter what you needed, she could find help for you. She still, even after I retired and I was searching for something, she was a go-to still for me. She has dedicated her life to emergency medical services, to caring and for others. Kathy has nothing but kind words for all. Even when folks were difficult, Kathy had kind words for them. Kathy and Vicki, but I'm going to speak to Vicki as well, they've been friends of mine and colleagues. We served together since 1992. Congratulations, Captain Doolin. And your resolution reads from both Senator Ward and I: in recognition of your retirement after 31 years of dedicated service to the state of New Hampshire and 39 to emergency medical services into your community as a provider of emergency medical services. And this is a resolution from the New Hampshire Senate. All right. Thank you all. And then moving on also to my colleague and friend, Captain Vicki Blanchard, serving the Granite State for 31 years in emergency medical services, 19 years of that as a state employee, also at fire training and emergency medical services at the Department of Safety. Vicki is a longtime paramedic. In fact, she was the first paramedic in Washington, New Hampshire, a remote community that needed access to an advanced level of care. You know, like, I don't want to say like no other, but she set a standard for smaller rural communities that you could achieve this and have that highest level of care out there. She took her advanced skill set and her passion for evidence-based patient care protocols and systems of care and put them to work on behalf of the entire state of New Hampshire. So we will, and I will share your resolution, Vicki Blanchard, Captain Vicki Blanchard, again in recognition of your retirement after 19 years of dedicated service to the state of New Hampshire and 35 years of service to the community as a provider of emergency medical services. Congratulations to you both. It's been one of my greatest honors to serve with you and to call you both my friends.
Oh my gosh, I'm not prepared for this. It's been an honor. I can still remember when I first got on an ambulance and started working, and I volunteered. I volunteered for 5 years before I had a full-time paid job. And I couldn't believe it when I got a paycheck. And I was like, I can't believe they're paying me to do this, because I love the work so much. And I love working with Senator Prentiss. She was my bureau chief for quite a long time. And she, if it wasn't for her, I feel like some of my opportunities I might not have had. So thank you, Sue.
Like Vicki, it has been my pleasure to work for Emergency Medical Services in the state of New Hampshire. It's a caring, wonderful group of people that need the advocacy of all of you, and we appreciate it. It's a pleasure. All my workmates up top, director, bureau chief, all of the officials, thank you very much. We appreciate the time today, and thank you for the recognition.
Senator Pearl, you have a very special guest, too.
I do. Thank you, Mr. President. I am honored to have my wife Evan join us here today. As I've said before, if it wasn't for her, I couldn't be here. So thank you for coming, and happy Valentine's.
Further introduction of guests. Seeing none. Without objection, Senator Carson.
I'd like to call a 5-minute recess.
Okay, we'll be in recess for 5 minutes. The Senate will please come to order. Without objection, the following bill. Committee on Finance, Senate Bill 219. And without objection, the following bill is special ordered to March 7th. In Health and Human Services, Senate Bill 559. Without objection, today's fiscal report is adopted. Moving to the consent calendar, Senator Carson moves that the consent calendar with the relevant amendments as printed in the day's calendar be adopted and that all such bills found ought to pass be ordered as follows. FN bills not waived under Senate Rule 45 to the Committee on Finance. Non-FN bills approved for referral to Finance by the day's FN report to the Committee on Finance. All other bills to third reading. Are you ready for the question on the consent calendar? All in favor, please say aye. Aye. Any opposed? The ayes have it. The consent calendar is adopted. The Senate will please be attentive to the clerk.
Thank you, Mr. President. The Committee on Judiciary, to which was referred CACR 24, a resolution relating to reproductive freedom, providing that all persons have the right to make their own reproductive decisions. Having considered the same, the committee recommends that the resolution is inexpedient to legislate by a vote of 3-2. Senator Gannon for the committee.
Senator Gannon.
Thank you, Mr. President. I move CACR 24 inexpedient to legislate. This constitutional amendment, concurrent resolution, would amend the Constitution to provide that individuals shall have a right to personal reproductive autonomy. But according to Planned Parenthood, abortion already remains safe and legal in New Hampshire. This legislature has been crystal clear and consistent when it comes to abortion rights. Women are able to get an abortion up to the 24th week and beyond in case of the mother's health or in a fetal fatal exception. For those who say this issue should go before the voters, it already has. The people have spoken and they elected us to represent them and their best interests. 75% of New Hampshire citizens support a 24-week with exception abortion policy. This resolution would do nothing meaningfully to protect the citizens of our state and only seeks to further divide us. This CRC is worded and it's been sanitized. It talks about freedom, rights, but this CRC isn't about that. It's about allowing abortion of a baby from the 24th week to the moment of birth, and that is not what the citizens of New Hampshire want. Furthermore, the language of the resolution is vague, especially when considering the high standard there should be for a constitutional amendment. On lines 3 and 15, mentions an individual's right, but it does not tell us who gets this right or when. Does it happen when the human individual is born, or when it's in the viable mother's womb, or at birth? Does an individual's right to personal reproductive autonomy apply to men? And if so, do they have a say in a pregnancy? The concept of considering the rights of the unborn is seen in other sections of law. For example, consider the murder of a mother and her unborn baby. The perpetrator would be charged with 2 counts of homicide, not 1. This bill does not recognize the concept of life until full birth. I find this unconscionable. For these reasons, a majority of Senate Judiciary asks for your support on the motion of inexpedient to legislate on CRC 24. Thank you, Mr. President.
Thank you, Senator Gannon. The motion is inexpedient to legislate. There is discussion. Senator Whitley.
Thank you, Mr. President. I rise in opposition to the ITL motion, and I rise in solidarity with the women who came before me and fought for equality. I rise for my grandmothers who had little choices about their future, and for my mother who became part of the first generation with actual reproductive freedom. And Mr. President, I rise for the little girls ahead of me who now have less rights than I had. Rights that led me directly to this chamber and helped me build a career, a family, and a life of my choice and of my dreams. Mr. President, when the U.S. Supreme Court overturned Roe v. Wade and the Dobbs v. Jackson Women's Health Organization case, they clearly eliminated the federal Constitution to access abortion. Since the Dobbs case was decided, it is without question that the legal landscape for reproductive rights and freedoms in our country is in absolute chaos. Granite State women have watched in horror as one in three American women of reproductive age have lost access to abortion care in their home state. This is staggering, and it hits close here in New Hampshire, as we have seen at best inaction and apathy towards protecting access to abortion, and at worst, the proposal of intrusive abortion bans, some as early as 15 days. The court in Dobbs clearly punted the issue of reproductive rights and freedoms directly to state elected officials. Colleagues, that means us. Justice Alito, writing for the majority in the Dobbs decision, said clearly, and I quote, "The authority to regulate abortion must be returned to the people and their elected officials, elected representatives," end quote. Yet we have done absolutely nothing to protect, codify, or enshrine reproductive freedom into our laws here in New Hampshire. Continued failure to act would be an abrogation of the role given to us directly by the U.S. Supreme Court. With no federal constitutional protections for abortion access, and New Hampshire only one of 3 states where abortion remains legal but not protected by law, it's imperative that we listen to Granite Staters who overwhelmingly want to see New Hampshire protect the right to abortion. Mr. President, we have been told time and time again that the absence of restrictions on abortion up to 24 weeks means that women shouldn't worry, that they should just trust politicians to do the right thing. But you don't need to be a lawyer to understand that the absence of restrictions does not equal an affirmative right. Women want reproductive freedom, and they are asking us to take action to protect it. They know full well that before Dobbs, they had the right to abortion, and then with one fell swoop, one decision, a half-century of jurisprudence, and the right to determine the course of their own futures was swept away. It's not hard to understand why Granite Staters are watching and waiting for us to act to protect reproductive freedom. New Hampshire has a long and bipartisan history of supporting privacy, particularly when it comes to personal medical decisions. Granite Staters pride themselves on living in one of the freest states in the nation and believe that government should stay out of our bedrooms, our homes, and out of our medical decisions. Passing CACR 24 would demonstrate that we respect New Hampshire's core values of individual freedom and self-determination. I want to be clear. Supporting this CACR does not mean you actually support the constitutional amendment. It only means that you think voters should decide this issue. It shows that you're listening to 87% of New Hampshire voters who support reproductive freedom. Let's trust our constituents to get this right. I ask you to think about the best and brightest young women in this country who are deciding where to go to college, where to start a family, and where to start a career. Will they look at New Hampshire, who has failed to act to protect their rights, or will they instead look to other states who don't just talk about freedom, but actually act to protect it? I know that Granite Staters have vast and nuanced personal and religious beliefs about abortion, and I'm not asking anyone to change their beliefs. However we feel about abortion, it is not our place to decide for someone else whether or not they should become a parent. Because whether or not to become a parent is one of the most important and personal life decisions we will ever make. And the freedom to decide this fundamental right is fundamental to ensuring that women are equal and full participants in society. Today, we have an opportunity to vote in line with Granite State's long-standing values of privacy and freedom from governmental interference. We have the opportunity to show women in the state that we understand that without the express freedom to determine the course of their own futures, Granite State women can never truly be equal. It's time to act to protect the fundamental rights of women in this state, to reassure half of the population that we will not tolerate further encroachment of our rights. Mr. President, I urge this body to vote against the ITL motion if they truly respect and trust women, to vote against the ITL motion if they respect and trust New Hampshire doctors, and to vote against the ITL motion if they respect and trust New Hampshire voters. Thank you, Mr. President.
Thank you, Senator Whitley. I believe Senator Abbas has a question for Senator Whitley.
Thank you, Mr. President. Is it true that on the Planned Parenthood website it says, quote, abortion remains safe and legal in New Hampshire?
Thank you for the question. I think I was clear when I stated that in New Hampshire, abortion remains without restrictions up to 24 weeks. But without restrictions doesn't mean that women have the same affirmative right that they had that was removed by the U.S. Supreme Court in the Dobbs decision.
A follow-up question? Thank you, Mr. President. But it's true that on the Planned Parenthood website, it does say, quote, abortion remains safe and legal in New Hampshire.
That may say that, and I would agree that there are no restrictions to access abortion up to 24 weeks, but no restrictions does not mean that women, again, have the affirmative right to access abortion without governmental interference, the right that they had several years ago, the right that I had several years ago, the right that I no longer have. Thank you.
Thank you, Mr. President.
Senator Chandley to speak.
Thank you, Mr. President. I rise to urge this body to overturn the committee recommendation and vote ought to pass on CACR 24, giving Granite Staters the opportunity to be the ones who make the decision on abortion access in New Hampshire. It has been just over a year since the Dobbs decision came down, and a year and a half, and the legal standing of women shifted in this country when that decision was made. On that day, the reality of women and mothers became even more complex as we now continue our lives managing our families, our jobs, our homes, but with fewer rights and choices than we had before. Those of us who have been pregnant know how challenging pregnancy can be. Under the best circumstances, when a pregnancy is wanted and welcomed, pregnancy can be difficult. We worry every day about the fetus that we carry. We often modify our diets, our activities, our family life to accommodate our pregnancy and give ourselves and our expected child the best odds for a healthy outcome. For some pregnant women, the reality is that they will face fear and sadness, illness, or injury. Whether it is because a pregnancy is not right for them at that time, that this moment in their lives is not the time they choose to be a parent, or because they or the fetus they are carrying are experiencing medical trauma, many women will then weigh their medical options. They should have the right to make their own decisions about their body free from political interference. CACR would put before the people of New Hampshire the question of a women's right to reproductive freedom, to bodily autonomy. It would ask the people of New Hampshire to affirm that women have control over their own bodies. CACR 24 is not a question about late-term abortions, nor does it pose the question as to when life begins. It asks, should people in our state be afforded reproductive freedom? To be clear, it asks the voters about personhood and about the rights associated with personhood. Are women persons with agency capable of making complex decisions about their own bodies? That is the question that would be asked should we put CACR 24 to the people to decide. Let us vote to overturn the committee recommendation and move forward with an ought-to-pass motion. Thank you very much, Mr. President.
Thank you, Senator Chandley. Senator Birdsall to speak.
Thank you, Mr. President. I just want to say, this body has voted at least 3 times on the 24 weeks. What the constitutional amendment does here is it wipes away talk about sweeping away. It sweeps away everything that we have voted. It would allow abortion up until the moment of birth with absolutely no restrictions. Only 7 states allow abortion up until the moment of birth. We have 14 states completely ban abortion, 2 states ban abortion at 6 weeks. We are at the lower end at 24 weeks. This is not what the majority of the country or our state is looking for. This bill does not define individual or reproductive autonomy. This could apply broadly beyond mere abortions. It would even take away the parental rights notification that we put in place years ago. CACR 24 is extreme. It's not what New Hampshire is looking to do. And almost 80% of our voters oppose allowing abortions up until the moment of birth. With that, thank you, Mr. President.
Thank you, Senator Birdsall. I believe Senator Abbas has a question for you also.
Thank you, Mr. President, and thank you for taking my question. Is it true that on the Planned Parenthood website it says, quote, abortion remains safe and legal in New Hampshire?
Yes, it does.
Thank you.
Senator Altschiller to speak.
Thank you, Mr. President. I rise today to respectfully ask this body to acknowledge the natural rights of all Granite Staters by overturning this ITL. I rise today to ask this body to acknowledge the sanctity of Article 1 of the New Hampshire Constitution. All men are born equally free and independent. And I rise today to ask this body to embrace the words and the spirit of Article 2 of our Constitution, which outlines our natural rights. All men have certain natural, essential, and inherent rights, among which are the enjoying and defending of life and liberty, acquiring, possessing, and protecting property, and in a word, of seeking and obtaining happiness. Equality of rights under the law shall not be denied or abridged by this state on account of race, creed, color, sex, or national origin. CACR 24 would add 31 more essential words as Article 2C of our Constitution. Those 31 words are: the right to make personal, reproductive medical decisions is inviolate and fundamental to the human condition. Neither the state nor any political subdivision shall infringe or unduly inconvenience this right. This amendment, like 2B, our right to privacy, which we adopted in 2018, states an individual's right to live free from governmental intrusion in private or personal information is natural, essential, and inherent. That is also about limiting government intrusion in our personal lives. CACR 24 grows naturally out of our existing Constitution and statutes. In fact, we have already enshrined in statute that our citizens have the right, founded in the autonomy and sanctity of a person, to control the decisions relating to the rendering of their own medical care. And yet, when that New Hampshire citizen is pregnant, the government horns right in. The pregnant person's rights to control decisions related to their medical care and the privacy of that personal information is interfered with by the state. Pregnancy is the line where constitutional rights are stripped away. Back to Article 1, all men are born equally free and independent. Therefore, all government of right originates from the people, is founded in consent, and instituted for the general good. CACR addresses the phrase, is founded in consent. The majority of New Hampshire residents do not consent to have the legislature involved in their reproductive health care. There is no caveat in Article 1 that says all men are born equally free and independent except when pregnant. And yet, the loss of freedom and independence is exactly what happens. Because of government interference, a New Hampshire citizen who is pregnant loses the benefit of making their own decisions concerning the protection of their life, their liberty, period. The rights to seek happiness by making reproductive medical decisions vital to their well-being is their natural right, and that's stripped away. They no longer have control over their own body. Their very lives are controlled by arbitrary presuppositions of legislators. Controlling, humiliating, and degrading women who have done nothing but be pregnant by stripping them of their natural, essential, and inherent rights is not the New Hampshire way. When a person does not have freedom over their reproductive decisions because of state interference, that is the definition of chattel. New Hampshire citizens value our natural rights, and it is an unjust and undue burden to restrict reproductive medical decisions. It's time to let the people decide whether to add 36 words to our state constitution or not. But by all means, keep this off the ballot if this November is what you really want is to continue controlling other people's reproductive choices. Keep it off the ballot if you believe that your religious choices should be everyone's religious choices. Keep it off the ballot if you are afraid to face the 87% of Granite Staters who support reproductive freedom. Or don't. This is a question of keeping it off the ballot or on the ballot. Make the right choice and include the voters in this choice. Embrace the challenge set forth by the Supreme Court when it sent this responsibility to the states. Trust the voters. Overturn this ITL and let the voters decide if they want to enshrine our reproductive freedom into our state constitution. We deserve nothing less. Thank you, Mr. President.
Thank you, Senator Altshuler. I believe Senator Gendro has a question of Senator Birdsall.
Thank you, Mr. President. If she'll take my question. So I just want clarification. I know you've mentioned it, I think, in your testimony, but would this CACR allow abortion up until the moment of birth with no restrictions? That is correct. Thank you.
Travis, I believe you have a question of Senator Altshuler.
Yes, Senator from District 24. And thank you for taking my question. Is it true that on the Planned Parenthood website it says, quote, abortion remains safe and legal in New Hampshire?
I think you spent a lot of time on the Planned Parenthood website. That's great. I hope you share that with your constituents, and I'm happy to hear that you are that interested in learning more about the reproductive health care of the citizens of New Hampshire. And honestly, I've not seen the Planned Parenthood website, but I'm going to take your word for it, since it seems like you spent a lot of time there.
Okay. And if I could just do a follow-up?
Yes.
And just to, I'm asking you what it says. No, I'm not saying it says that. So I'm just going to ask the question again. is it true that on the Planned Parenthood website, it says, quote, abortion remains safe and legal in New Hampshire?
If that is what you read, I will trust that that is what you read. I have not seen the Planned Parenthood website recently.
Thank you.
Thank you very much. I now recognize Senator Carson, our final speaker, I believe.
Thank you, Mr. President. As always in this chamber, we have very good, enlightened discussions about issues that are facing the people of this state. It's a little baffling why we keep coming back to this. We passed a very reasonable abortion bill. Some have termed it a ban. It is not a ban on abortion. A woman can have an abortion at any point up to the end of the 24th week, which is the end of 6 months. So you ask, well, why there? Because medical science has determined at that point that fetus or child is capable of life on its own. It will need medical intervention, but it is capable of life. And shouldn't we be about preserving life? Are we saying that that life has no value because the mother doesn't want the baby at that point, and she should be able to get an abortion right up until the day of? We're saying no. And we've heard a statistic this morning, and I'd like to point out that over 80% of New Hampshire voters oppose late-term abortion because that is the only thing that has been banned in the state of New Hampshire. A woman can go at any point within those 24 weeks and have an abortion, no questions asked. That is reproductive freedom. That is choice. You don't have to fill out a paper saying, this is why. We don't do that. You can get it done. It's your choice. Now, we know other states are not as good about this as we are. And in fact, 43 states prohibit some abortions after a certain point in pregnancy. So we are not outside the norm here. We are well within those 43 other states. 14 states ban abortion outright. We did not do that here. 2 states ban abortions up to 6 weeks. Guess what? We don't do that either. 2 states ban at 12 weeks. Again, we don't do that here. 2 states at 15 weeks. Again, not in New Hampshire. 1 state bans at 18 weeks. Again, not in New Hampshire. 4 states at 22 weeks. 4 states at 24 weeks. 12 states impose a ban at viability. And 1 state imposes a ban on the 3rd trimester. What we did was reasonable. But it has been depicted as a ban, outright ban on abortion. I can't tell you when we first passed that bill how many young women said, oh my God, the state of New Hampshire banned abortion. It was not true. Now, how did that discussion even begin to happen? Well, we need to ask ourselves and take a good look and say, okay, how did this misinformation get out there? Because this is what we've been struggling against. A woman can go at any point within those 24 weeks and have an abortion, no questions asked. But for some people, that's not good enough. We have to have a right. Well, as we've seen in the Dobbs decision, you can put a right into the Constitution, but it can also be taken out too, can't it? So where are the real protections? The real protections are here for those of us that continue to fight against abortion up to the moment of birth, which the vast majority of New Hampshire citizens do not support. But they do support up to 24 weeks. And that's what we continue to fight for. But for whatever reason, we just keep having to come back here. People feel you need that right. Well, okay, I understand that. But I think we also need to ask ourselves, where's the federal government in all this? Why hasn't the Biden administration done something about this? Where's the executive orders protecting women's rights? I saw something about it, but what's happened? Where's Congress? What have they done to protect women's rights? I also question the fact that CACR 24 is extreme. And let me ask you, what does reproductive freedom mean? Are we talking about abortion? Still, let's call it what it is. Be very clear, because the Constitution is supposed to be clear. The state of New Hampshire is telling women you can get an abortion at any time during a pregnancy. Be honest and tell them exactly what it is. Reproductive freedom, are we talking about birth control? You have a right to birth control? It's vague. Oh, and let's not forget a good number of other people in our society. What about our men? Do they get reproductive freedom as well? Do they now get a say in a woman's pregnancy? If she doesn't want the baby and he does, where's his rights? Where do they come in? You open a door with this amendment that I don't think you want to open. It's not clear, and it's extreme, and we should not be voting for it. Thank you, Mr. President.
Thank you, Senator Carson. I believe Senator Waters has a question of
District 15.
Senator Whitley.
Thank you for taking my question. So we've heard the question as to why this issue keeps returning to us. And wouldn't it be fair to say that it returns to us because of the overturning of Roe versus Wade, and that it returns to us because we have presidential candidates now who have signed in their own state or are advocating a 15-day ban, and members of Congress who want to call for a national ban? So that in these circumstances, isn't the only way that a state can protect its rights, since our statute explicitly says there is no right to an abortion construed in this existing right, or freedom, I should say, so that without a constitutional amendment, we can't defend ourselves against overreach and extremist activities from the federal government?
Yeah, I would agree. I think that's exactly right. I think that voters and constituents are very clear that the Dobbs decision, the justices said very clearly that this is an issue to be decided by states. They see that the president has done what he can. He has issued executive orders. Other governors have issued executive orders. Ours, unfortunately, haven't. So I think they're very clear that other states are doing things that are removing access, and other states are protecting access, and they are looking to us, they are asking. And what I know, too, in answer to your question, is that this is a top issue for people, and that's why we are being responsive to it. You know, this body voted down putting this into statute, okay? Now we're putting it into the Constitution. So we are doing everything possible to address what people are asking us to do.
Thank you.
Thank you.
Thank you, Mr. President.
Thank you, Senator Waters. Senator Altshuler, you have a question too, I believe?
Yes, please, Mr. President. For my colleague from District 14, if she will take the question.
Senator Carson.
Thank you very much for taking my question. Sure. And I'm want to preface my question because you had just talked about your question of, well, what about men, and do they get to make reproductive decisions for other people? And I'm wondering if you had read the actual language that says an individual's right to personal reproductive autonomy is central to the liberty and dignity to determine one's own life course. And with the confidence of your very emphatic assertion that this is settled matter, what is the fear of putting it to the voters? And if indeed your assertion that you so emphatically laid out for us is true, then you walk away a winner. Why not let the voters weigh in on their own personal reproductive decisions?
Thank you, Mr. President. I think there were 3 questions there, and I'm going to attempt,
one.
because you asked about the personal freedom, and then there were 2 others. You're right. I have read this. In fact, I've read it many times, and it is not clear. This is where, at the end of my conversation, I said this is unclear. Men are entitled to personal reproductive freedom, correct? Because everyone in it, because it's all individuals, okay? So that includes men. So what happens if they want the child and the woman doesn't? Whose freedom comes first? Whose right comes first? Is it their right because they've contributed half of the genetic material, or is it the woman's right because she has half and she's carrying the child? Does that trump everything? This is the problem with this amendment. It is not clear, and it's not ready to come forward to our Constitution. We have the duty and the responsibility to make sure that it's clear and people can understand it when they read it. This is not clear. It is not clear about how long, right up to the day of birth, how old. Not clear. We've got to do better. The people are owed that. And again, you asked about people voting. The people have spoken. They don't want late-term abortion. That's what we've done. We have a very reasonable statute. In fact, most people have voted for this in this chamber on different occasions in an attempt to put this into our Roe versus Wade statute. So obviously, based on that, it's not that bad. But what you're looking for is to put a right into the Constitution. But this is not the right language. This is not the right constitutional amendment. The people deserve better than this. Thank you.
Further question? No further question. I think Senator Whitley, you wanted to speak again. You're recognized.
Thank you, Mr. President. I appreciate this nuanced conversation about our current restrictions on abortion, and why a CACR is so important. And we have all read this. I know we have all read this, and it says nothing about our current restrictions, because this is a constitutional amendment. As we all know, the rights defined in our Constitution are not a statute. They are rights to be further fleshed out by the courts. And I think everyone now is so familiar with how a constitutional right works, both our federal Constitution and our New Hampshire Constitution. So again, this CACR sets the right, just like any other right, and then it is our job as elected officials to define further restrictions. Nothing in this CACR prevents us from doing that. I want to be clear about that. And just with any other CACR, if there is a restriction, it would likely be brought to court, and the court would balance any compelling governmental interest presented, just with any other right? As we know, not every single right is absolute. It must be balanced by a governmental compelling interest. So I know that we all want to bring it back, or my friends on the other side of the aisle want to bring it back to our current restrictions, but that's not what this is about. This is about protecting in the Constitution a fundamental freedom for half of our population. And then it's up to the courts to decide, just like they do in every other state. So I want to be clear about that. I think it's misleading to present this as saying, women, or, we are supporting abortion right up to the moment of death. Of birth. That's not how abortion works. That's not how medicine works. I think that's very misleading. And what I know is that I trust women to make the best decisions for themselves. My friend from District 21, who's not here today, often says about her own pregnancies and the pregnancies of other women, trust us. We know what's best for our families. We know what's best for our futures. Trust us to make those decisions. I also want to address the issue about the fact that, this language is not clear, that it could apply to everyone. And that, why isn't the term woman used in the CACR? And I would respond by saying, would all the laws and constitutional provisions referring to only men not apply to women by that logic? I think by raising that issue, we've highlighted exactly why women have been fighting for the Equal Rights Amendment for over 50 years. So I think that's a bit of a red herring. And I think when we're talking about how women in this state feel about why there is confusion, to me, it doesn't matter. Is it because of our current restrictions? Is it because politicians all around the country and in New Hampshire are proposing bans on abortion in this state starting at 15 days? Is it because we have not acted to protect or enshrine the right? It doesn't matter why the confusion is, but there is confusion. Granite Staters are looking to us to clarify the right to abortion. They are looking to us. And in fact, the Supreme Court said, it's our job. It's our job to clarify, and that's what we are asking to do. Thank you, Mr. President.
Thank you, Senator Whitley. Senator Abbas for a question.
Thank you, Mr. President. Mr. President, question from the senator from District 14.
Senator Carson.
And thank you for taking my question. I know you said that there's been confusion, so I just want to emphasize this question again. You probably heard this question. But is it true that on the Planned Parenthood's website, it says, quote, abortion remains safe and legal in the state of New Hampshire?
Senator, you are exactly correct.
Thank you.
Thank you.
Senator Whitley, do you have a question?
Thank you. Of my colleague from District 11.
Senator Chan.
Yes, certainly.
Thank you for taking my question. So you heard the conversation, the dialogue about our current framework and about viability. And we heard from our friend from District 14 that medical science actually says that viability is 24 weeks. But isn't it the case that we actually heard something quite different in judiciary? That we heard that viability is different for every pregnancy, that it may be certain weeks for one pregnancy and certain weeks for another pregnancy. Isn't it true that we heard from our experts, our New Hampshire providers, our OBGYNs, that viability is not a bright line, that it's very hard to come up with any bright lines or any hard and fast rules because pregnancy is so unique for every single woman?
Yes, you are correct. That is what we heard from the expert testimony.
Thank you.
Senator Birdsall to Speaker for a question.
I'll speak.
Senator Birdsall.
Thank you, Mr. President. As the good senator from District 14 said, I value the conversation we're having, but I just want to remind everyone that this constitutional amendment will allow abortions up until the moment of birth with no restrictions. It wipes away all of the votes that we have taken in this body on our 24 weeks. And when we talk about the 15 days, that is on the other side of the aisle, and it is a dead deal. Clarifying, according to the good senator from District 14, this amendment is not ready for prime time. It is vague, as I had said before in my previous speech. It's vague, there's a lot of questions. It's not ready. So with that, I will stop, Mr. President. But again, remember that this allows abortions up until the moment of birth. Thank you.
Thank you, Senator Birdsall. Senator Ward for a question of
The good senator from District 14.
Senator Carson.
Yeah, this is probably reiterate something that's already been said several times today in questions. But isn't it true that the CACR allows abortion up to the moment of birth without restrictions? Thank you for this question, Senator. Yes. Thank you. Thank you.
Senator Whitley.
A question of my colleague from District 11.
Senator Chantley.
Certainly. Go
Thank
ahead.
you, thank you. So the issue that was discussed about, the fact that this is a CACR versus the restrictions, we talked about this in committee. And isn't it true that, as with any other constitutional right, the Constitution doesn't define, is not the place where we define details. That's in statute, and that's the role of the courts to interpret. That's why we have a Supreme Court. Isn't it the case that, a constitution is the place to define rights, and then statute and jurisprudence from our Supreme Court is the place to define the nuance. Isn't that correct?
That's absolutely correct. The Constitution enumerates our rights. The specifics are addressed in statute and through the court interpretation. Thank you for the question.
Senator Carson to speak.
Thank you, Mr. President. As always, great discussion this morning. And I think it's taken a turn that I find very interesting, because we've heard people speak this morning, our colleagues, about we need this. We need to have this. Women have spoken. We need to turn it over to the voters. Let the voters decide about the constitutional amendment. But now we're hearing about the courts. So who is it? Who's going to be the final determinant? Is it going to be the people, or is it going to be the courts? Versus the statute, which is very clear. The statute which says a woman can have an abortion in the state of New Hampshire up until the end of the 24th week, no questions asked. After that, fatal fetal anomaly, health of the mother. Very clear. So now we're talking about the courts. I wish people could make up their mind who is going to be the final determinant. Don't mislead the voters and let them think we're going to put this in our Constitution and we can do whatever we want. That's not the case. But the statute is very, very clear. Thank you very much, Mr. President.
Thank you, Senator Carson. The question is on adoption of the committee recommendation of inexpedient to legislate on CACR 24. This is a constitutional amendment. A roll call is required. The parliamentary procedure is as follows. If you're in favor of the motion of inexpedient to legislate, you would say yes. If you are opposed to that and want some other outcome, you would say no. Everybody clear? The clerk will please call the roll.
Senator Gendreau.
Yes.
Senator Lang.
Yes.
Senator Waters.
No.
Senator Prentiss.
No.
Senator Gray.
Yes.
Senator Innes.
Yes.
Senator Ward.
Yes.
Senator Ricciardi.
Yes.
Senator Fenton.
No.
Senator Chanley.
No.
Senator Avard.
Yes.
Senator Rosenwald.
No.
Senator Carson.
Yes.
Senator Whitley.
No.
Senator Murphy.
Yes.
Senator Pearl.
Yes.
Senator Susie.
No.
Senator Birdsall.
Yes.
Senator D'Alessandro.
No.
Senator Perkins Kwoka is excused. Senator Abbas.
Yes.
Senator Gannon.
Yes.
Senator Altschiller.
No.
Senator Bradley.
Yes. The ayes have it. The motion of inexpedient to legislate is adopted 14-9. Let's take a 2-minute recess. The Senate will resume its business, please, and please be attentive to the clerk.
Thank you, Mr. President. The Committee on Judiciary, to which was referred Senate Bill 322, an act relative to licenses to carry. Having considered the same, the committee recommends that the bill is ought to pass with an amendment by a vote of 3 to 2. Senator Abbas for the committee.
Senator Abbas.
Thank you, Mr. President. Thank you, Mr. President. I move Senate Bill 322 ought to pass with amendment. And this legislation requires a license authorizing an individual to carry a loaded pistol or revolver in this state to include the name, title, and signature of the person issuing the license. The committee amendment would provide immunity to law enforcement officers who in good faith issue a license under RSA 159:6 or under RSA 159:8 from any liability arising from certain actions by the firearm licensee. This legislation was brought forth by a concerned citizen who was trying to get a signed pistol revolver license in New Hampshire. Some police officers were hesitant or refusing to sign these permits as they were put in an uncomfortable situation, because if an officer could no longer consider if someone was a suitable person, they didn't feel it was appropriate to make the chiefs or the law enforcement agency sign the document. This legislation with the committee amendment is a reasonable compromise, as those who want a PRL signed can get it while absolving the police officer who is issuing the license from any liability concerns. For these reasons, the majority of the committee, for these reasons, a majority of the Senate Judiciary Committee asked for your support on the motion of ought to pass with amendment on Senate Bill 322. Thank you, Mr. President. If I can just briefly be heard.
You want to continue to speak?
Just briefly.
Yes, please.
And New Hampshire's a constitutional carry state. We do know that, but understand when someone, if for purposes of reciprocity, if someone were to go other states like Vermont or Maine, that's the common situation where someone, a resident in New Hampshire, would actually just receive a PRL. So just understand, this protects that, a New Hampshire resident when they travel out of state and to comply with the other state's law to honor the reciprocity. Thank you, Mr. President.
Thank you, Senator Abbas. Senator Chandley to speak.
I would speak to the bill as amended.
I'm sorry. My apologies. All right. The bill is on second reading. The first order of business is the committee amendment. Any discussion on the committee amendment? Roll call. Second. Roll call has been requested on the amendment. If you're in favor of the amendment, you would vote aye. If you're opposed, you would vote no. Are you ready for the question? All in favor, please say it. The clerk will please call the roll.
Senator Gendreau.
Yes.
Senator Lang.
Yes.
Senator Waters.
Yes.
Senator Prentiss.
Yes.
Senator Gray.
Yes.
Senator Innes.
Yes.
Senator Ward.
Yes.
Senator Ricciardi.
Yes.
Senator Fenton.
Yes.
Senator Chandley.
Yes.
Senator Avard.
Yes.
Senator Rosenwald.
Yes.
Senator Carson.
Yes.
Senator Whitley.
Yes.
Senator Murphy.
Yes.
Senator Pearl.
Yes.
Senator Susie.
Yes.
Senator Birdsell.
Yes.
Senator D'Alessandro.
Yes.
Senator Perkins Kwoka is excused. Senator Abbas.
Yes.
Senator Gannon.
Yes.
Senator Altschiller.
Yes.
Senator Bradley.
Yes. The ayes have it, 23-0. The amendment passes. The bill is still on second reading. It's open for further discussion or amendment. And now I will recognize Senator Chandley.
Thank you very much, Mr. President. I rise in opposition to the bill as amended because I do not believe that it resolves the problem it seeks to address. Up until a few years ago, we had in place a concealed carry permitting process. It wasn't a complicated process, but it was a process nonetheless in which residents of our state could be granted a concealed carry permit or, under certain conditions, denied that permit. The permit was good in our state, and it was also recognized out of state. Fairly recently, that permitting process was eliminated. The House and the Senate passed legislation to eliminate the permitting process. The governor signed that legislation, and many proponents they cheered the right to what was then called constitutional carry. So no one no longer needs a permit to carry a concealed weapon in the state of New Hampshire. That's fine. Of course, what then do people from New Hampshire do when they wish to carry a concealed weapon while traveling out of state? They need a permit. Current law requires that town officials issue a permit to anyone who would like one, unless the applicant is prohibited by New Hampshire or federal statute from possessing a firearm entirely. No other information may be considered, nor can any other discretion be exercised. Suitability is not determined by the person who is issuing the permit, who is by this legislation required to sign the permit. It was brought to the attention of the prime sponsor that the permits that many people were being issued were not in fact signed by any official. In an attempt to rectify the situation, the sponsor brought forward this legislation. However well-intended, I do not believe the problem is resolved. I just voted with the majority to offer immunity to those who signed the permit. How can I not? If we are asking people to sign a document but not allowing them to use their discretion, I do think we need to offer them immunity, but I don't think that is the right way to proceed. Can I ask anyone to sign that permit to allow another person to carry a concealed weapon when in fact there is no real vetting process? Can a person be charged with that responsibility? Is that person ever allowed to say no? Only under the circumstance where the person is not allowed to possess a firearm under any circumstances. It doesn't appear that there's any other option. I believe that it is irresponsible to pass SB 322. In doing so, we are asking our chiefs of police, our town councilors, our mayors, our select board members to put their names on a document attesting to someone's suitability to carry a concealed firearm without giving those same chiefs, councilors, mayors, and select board members the ability to determine unsuitability. We cannot have it both ways. We cannot say that a permit is required to carry a concealed firearm, that a permit is not required to carry a concealed firearm in the state of New Hampshire, but then issue a permit to do so elsewhere without a formal process in place. We cannot ask someone to be responsible for issuing that permit if, in fact, there isn't a process in place for vetting an individual suitability to carry concealed. Thank you very much, Mr. President.
Thank you, Senator Chanley. The question is on adoption of ought to pass as amended. Senator Carson to speak.
Yes, thank you, Mr. President. I rise in support of the ought to pass motion. My colleague from District 11 is correct in some areas. We did pass a constitutional carry, but we kept the permit itself in place because we realized there are states that we have reciprocal agreements with, and there are other states that still ask to see a permit. Those folks are running into difficulty because they're not being signed. So it's kind of, I guess, maybe like getting your driver's license without it being signed by the state, saying that you are a legal driver. What this says is you can legally carry a weapon, that you have met our statutes. And we had testimony, and I will refer to Ms., I don't want to say her name, who is someone who tried to get the license. She is a firearms instructor, and she got some grief because she kept the permitting. And the chief did not sign it, refused to sign it, and she sued. And the court ruled that the chiefs are not legally bound to sign the permit, and legislation is the remedy to the problem. So what you have in front of you is a remedy to the problem. They have to sign it. There are statutes, we have federal requirements, and we have New Hampshire statutes that are in law. So this very simply says the chief must sign the permit if the person is qualified to do so. We took away the discretion because, and I remember from years ago when I was in the House, that women were being denied to get a permit to carry because they had menfolk that were going to protect them. The argument didn't go over too well in the House, as you can imagine. And that's one reason why this went forward. So again, the court's asking for a remedy to this. This bill answers that question. Thank you very much, Mr. President.
Thank you, Senator Carson. Senator Whitley, a question?
A question of my colleague from District 11.
Senator Chandley.
Yes. Thanks for taking my question. In Judiciary Committee, there was no testimony or evidence presented that people are being denied a permit. Isn't that correct?
Correct.
And isn't it true that a chief is required to issue the permit, assuming that the person is not prohibited under law from receiving it?
That is correct.
Thank you.
The bill is on second reading. It's still open for further discussion. Senator Carson.
Thank you, Mr. President. I feel at this point I need to clarify, and I'm looking at the hearing report. It wasn't that an individual was denied the permit. It's the fact that the chief refused to sign it. And that's where the problem lies, and that's what this piece of legislation is attempting to fix. The court has said it needs a legislative remedy, and all this bill does is say the chiefs, or whoever is the issuing authority, must sign it, because these licenses are going to be used in other states. And what good is it if it's not signed? Thank you very much, Mr. President.
Excuse me. Thank you, Senator Carson. Bill is on second reading. It's open for further discussion and questions. Senator Lang.
Question from my colleague from District 14. So it'll be a small series of questions to make sure I clearly understand this. So we still have a permitting process for concealed carry. Correct?
Yes.
And that process has criteria that if you meet that criteria, a permit has to be issued.
Yes.
There are chiefs out there that are not signing the permit due to fear of liability across the board. Whether suitability is the issue or not, they're just not signing it to everybody and just issuing a permit, correct?
There are some, yes.
And lastly, that this seeks to remedy that issue so that the chiefs aren't personally liable for a signature on the form that they're doing by law, so that our citizens who are disadvantaged when they travel out of state don't run into issues.
You are correct.
Thank you.
Senator Susi for a question of
my colleague from District 11.
Senator Chandley.
Certainly. So this makes the question I was going to ask before my colleague from District 2 stood up even more important. I'm looking at the statute, RSA 159.6 Roman 1A. There is no process. There's simply a designated person who previously, many of the chiefs said they didn't sign because they were being asked to sign something where they had absolutely no discretion. So instead of providing criteria and discretion, we're saying you have to sign it, but if something goes wrong, you get immunity. Is that right?
Thank you very much for that question. You have summed up exactly the problem. It seems to me a circular argument to suggest that the problem is with the immunity, not these discretion and suitability decision being made. We heard from that at least some, and I cannot, we certainly did not hear this from all, but some folks were writing in the RSA in the place where they would normally have signed because they were not comfortable putting their signature on the permit. There is not a process other than, the only criteria is that you are not prohibited by state or federal law from owning a firearm.
Thank you.
Senator Abbas to speak.
Thank you, Mr. President. I just want to, there seems to be some confusion on what's actually happening here. If the police are going to issue the permit, there was no reason why they wouldn't sign the permit if they issue it. I understand they don't want to be liable, but they're still issuing the pistol permit. All right, so the New Hampshire resident has the permit now that was given to him by the police, and records in that department will show who they met with, who was there when they filled out the application. All that's going to be documented in the police department. So if someone wants to know which officer or who was the designee who helped issue that permit, they're going to find out that information anyway. This is just straight up signing it, so when they're in another state and the other state wants to see a signature on the permit to verify that it's a valid permit, that's what the other states are asking. So and if those states offer reciprocity in New Hampshire, they appreciate the laws we have in place, and they're honoring those. And the problem is when people go to Vermont or Maine or any other state that there is reciprocity, that's where New Hampshire residents are having a problem. This will resolve that problem for them out of state. They still have the permit, it's just the problem in the other state gets resolved. And that's what this is intended to do. This isn't about who should get a permit and who should not get a permit. That's a separate conversation altogether. But please join me and support the motion of ought to pass as amended. Thank you, Mr. President.
Thank you, Senator Abbas. Further discussion. Senator Pearl. Question.
For my colleague from District 14. Is it reasonable to assume that if a person was in another state with a license that had a spot for a signature and there was no signature on that, that the authority that was looking at that, trying to determine whether this person was legally allowed to carry this concealed permit, is it reasonable to assume that they would feel that license is not valid without a signature?
Yes.
Thank you.
Senator Whitley for a question.
My colleague from District 11.
Senator Chandley.
Thank you, Senator, for taking my question. We heard in Judiciary, we're hearing on the floor today, that the problem that we're trying to solve is the fact that if someone travels out of state, perhaps a state like Maine or Vermont won't recognize it. I don't think there's a lot of evidence of that actually happening. But if that's the problem we're trying to solve, isn't the solution to work with these other states to understand interstate commerce requirements, to understand our law? Isn't that the solution to the problem that has actually been presented?
I think you pose a very good suggestion, and I do believe that was asked during our hearing. Are there standards that are presumed if we are issuing a permit? Is there a certain standard that has been met, presumed to have been met? So, thank you.
Senator Pearl to speak?
No.
Senator Pearl declines. All right. The question is on ought to pass as amended. Is there any further discussion? Seeing none, are you ready for the question? Senator Avard has asked for roll call. Senator Lang has seconded. The clerk will please call the roll.
Senator Gendreau.
Yes.
Senator Lang.
Yes.
Senator Waters.
No.
Senator Prentiss.
No.
Senator Gray.
Yes.
Senator Innes.
Yes.
Senator Ward.
Yes.
Senator Ricciardi. Yes. Senator Fenton.
No.
Senator Chandley.
No.
Senator Avard.
Yes.
Senator Rosenwald.
No.
Senator Carson.
Yes.
Senator Whitley.
No.
Senator Murphy.
Yes.
Senator Pearl.
Yes.
Senator Susie.
No.
Senator Birdsell.
Yes.
Senator D'Alessandro.
No.
Senator Perkins Kwoka is excused. Senator Abbas.
Yes.
Senator Gannon.
Yes.
Senator Altschiller.
No.
And Senator Bradley.
Yes. The ayes have it 14-9. The motion of ought to pass as amended is adopted. Senate Bill 322 is ordered to third reading. The Senate will please be attentive to the clerk.
Thank you, Mr. President. The Committee on Judiciary, to which was referred Senate Bill 360 FN, an act relative to extreme risk protection orders. Having considered the same, the committee recommends that the bill is inexpedient to legislate by a vote of 3-2. Senator Carson for the committee.
Senator Carson.
Thank you, Mr. President. I move Senate Bill 360 FN inexpedient to legislate. This bill would establish a procedure for issuing extreme risk protection orders to protect against persons who pose an immediate risk of harm to themselves or others. This bill raises significant constitutionality concerns. A person who has not committed a crime would be deprived of their Second Amendment constitutional rights based on an accusation and a judge's determination. When a defendant has had their weapons confiscated, they would have to obtain legal counsel in order to retrieve them back. This is a direct cost to the accused, not the accuser. Even if an accused individual can afford counsel, it is possible that their weapons could be damaged or, in some cases, lost. For years, the legislature has heard from advocates about stigmatization and the effect on those with mental illnesses. This bill would further stigmatize these individuals and prevent them from receiving treatment with fear. Other states that have enacted similar legislation have had horrific tragedies that were not stopped. In fact, the committee heard testimony that 128 gun-related suicides were prevented in Connecticut over 10 years. During the same period, however, the law may have contributed to 140 non-gun-related suicides. Given the serious constitutional concerns and that there are existing statutory remedies in place to address individuals who pose a danger to themselves or others, the majority of the Judiciary Committee asks for your support on the motion of inexpedient to legislate on Senate Bill 360 FN. Thank you, Mr. President.
Thank you, Senator Carson. Senator Waters to speak.
Thank you, Mr. President and colleagues. I rise in opposition to the pending motion. I want to take just a few minutes in my remarks to talk about suicide issues and why this bill would be helpful and necessary in that. I mean, New Hampshire does, of course, continue to face a mental health crisis, and that tragically for some people, this can manifest with suicidal thoughts. Now, you know, we have certainly tried to take action in other mental health crises. We've done it with opioids, haven't we? And done a lot of activities trying to reduce risk and losses there. And I will say, I think we've done that without creating additional stigma. And that's been a good thing. And I think that there's an opportunity here to do the same, the same with this, and to take reasonable steps to reduce risk. You can't reduce risk 100%, but certainly we can do something to reduce risk of suicide, particularly with firearms. Now, you know, in New Hampshire, sadly, suicide is the second leading cause of death after unintentional injury for people aged 10 to 34. And, you know, in particular, in 2020, 89% of all deaths in New Hampshire involving a firearm were suicide deaths. Between 2015 and 2020, 55% of male suicide deaths in New Hampshire involved a firearm, 28% of female suicides deaths in New Hampshire involved a firearm. Between 2015 and 20, 71% of male suicide deaths of U.S. Armed Forces members in New Hampshire involved a firearm. We know from the Youth Risk Behavior Survey, not only nationwide, but for New Hampshire, that suicidal ideation among high school youth in New Hampshire increased between 2011 and 2019. And lots of reasons for that. The New Hampshire Suicide Prevention, in a report of 2021, noted that 50% of New Hampshire residents who die by suicide do use a firearm. And we have had, sadly, a suicide rate above the national average for more than 10 years. And now about half of New Hampshire households have a gun. When someone uses a firearm to attempt suicide, that attempt is lethal 90% of the time. It is the most lethal means available. Now, in previous debates on this matter, we have had discussion about, well, if somebody really wants to commit suicide, they're going to do it anyways, no matter what we do in statute. I wanted to kind of drill into that a little bit, particularly with youth, but I think these factors apply to all folks. Youth suicide rates are up 60% since 2011, going from 6.9 to 100K in 2001 to 11 to 100K in 2021. Now, let us note this is concurrent with a massive increase in the number of guns possessed in the country and a massive increase in the number of guns in households in the country. It is, as I said, the second leading cause of death. And then, think about where our high school students are. 18.8% of high school students seriously considered suicide in the last year. 24% female, 46% of LGBTQ teens, 8.9% actually attempted suicide in the last year. Females 11%, LGBTQ attempts 23.4%. Now, this question about does the means make a difference, the availability of means. And, again, we've had stated on the floor of the Senate that, the means does make a difference. Somebody want to do it, they want to do it, and so forth. And I just wanted to reference why that is not actually the case, and that the increase in the number of guns in this bill, which would try to provide a process where when someone needs an extreme risk protective order, that the primary most fatal means might be removed from the household. So in 2022, JAMA, Journal of American Medical Association article, said that methods of suicide is a strong determinant of suicide fatality, a strong determinant, the method used. I said before, 92% of attempts with firearms are fatal. Now, they actually, it's very interesting, they did some study of other countries saying, well, is the method available, have a determinant? And, bizarre as it may be, in Switzerland, lots of mountains, right? The most commonly used method is jumping from a high place. And they have very few guns. But you might survive a little more if you take a jump. And also, since firearms are the leading cause 2011 to 2020, in that huge increase, the proportion of deaths then involving firearms increased. And just to quote from JAMA, say, prevention of suicide involving firearms through restriction of access remains urgent. Easy access influences the choice of method. And I'll just pause for a moment to say that this certainly was the case in a teenager that I knew. Having some difficulties. And there was a .22 in a closet. And one afternoon, that's what happened. If the gun hadn't been there, probably the afternoon would have passed, and that person would still be alive. And I know a lot of our families have been touched by suicide and suicide attempts, and it is the firearms in this case. One last thing I'll say too is that we've had that conversation about impulse and determination. So I decided to look at particularly this issue of impulsivity, and how that affects the fact that if you're impulsive and you decide, I'm going to try, that if there's a firearm there, you're much, much more likely to have a fatal injury than if you impulsively might try another method. And just looking at the Youth Risk Behavior Survey, they say that for those who consider suicide, about 25% of those people just impulsive, but they had no plan. Had no plan, but they had the impulse. And then there were about 22% who were impulsive and had a plan, and then some people who had a plan but were not, you wouldn't identify as having impulsive repulsive behavior. Now, when this occurs, ones that are completed that result in fatality, 52% with firearms. Overdose, 18%, or poison. Overdose and poison combined together. Suffocation, and sadly, I will note that still the primary cause of death for females attempting suicide is by hanging, other means of asphyxiation. But if you look at what the physicians say about what they're seeing about being able to, the people who recover from these attempts, 90% the firearm don't recover. But 64% of the people who come to the emergency room and recover, that's from the overdose or from the poison or from the asphyxiation. So I just think that, you know, when we talk about this, the method makes a difference. And that's why this bill will make a difference, because it will allow people to take this action with constitutional protections, much like we already do with domestic violence. Same process in a way in this bill, but it's saying this method, if we can remove this method, we will reduce successful suicides. Thank you, Mr. President.
Thank you, Senator Waters. Senator Altschiller to speak, please.
Thank you, Mr. President. I rise in opposition to the committee recommendation of inexpedient to legislate. Remember this past October when we assembled right here for Veto Day? That was Thursday, October 26th. 18 people were murdered and 13 more injured with gunshot wounds, and the state police in Maine issued a shelter-in-place order for the city of Lewiston. They were a community under siege. The Lewiston shootings were preventable. The shooter was an extreme risk to the community and subsequently shot himself. An extreme risk protective order like Senate Bill 360 would have helped. The signs of impending danger were everywhere. Yesterday was the 8th anniversary of the murders at Marjorie Stoneman Douglas High School in Parkland, Florida. 17 people were slaughtered, 17 more seriously injured by gunshot wounds, and another community traumatized. Prior to the Valentine's Day murders, the shooter's family, friends, had openly expressed deep concern for the shooter. We now know, after the funerals, this 19-year-old had the worried attention of social workers, his teachers, sheriff's deputies in 2 counties, and the FBI. The warning signs of his escalating behaviors were everywhere. Another recent and notably preventable shooting was in Houston, Texas, at the Lakewood Church. The shooter, with a documented history of violence known to law enforcement, is now dead, and her 7-year-old son is fighting for his life. And a churchgoer was also shot. And yesterday, at the joyful Kansas City Chiefs Super Bowl victory celebration, another mass shooting. 1 dead, 22 more victims injured, 11 of them children. 8 of those 22 people are in critical condition. So far this year, we have had 49 mass shootings in America. But not in New Hampshire, right? Not in New Hampshire. Didn't we get ranked 2nd safest state in the nation behind Maine? Sure we did, by U.S. News and World Report. What about that? Those statistics don't include suicide. They released that report 5 months before the mass murder in Lewiston that killed 17 people and wounded 13 more, traumatizing an entire community. So that's going to change the ranking for Maine. So about those ignored suicide rates. In 2021, New Hampshire buried 223 people who died by suicide, and the Granite State ranks 12th in the country 12th in the country for suicide deaths. That doesn't make the U.S. News and World Report ranking. New Hampshire has preventable suicides in every single county. They don't make the front page, they're not at the top of the news hour, but there they are, occurring in the homes of our constituents, leaving a ripple of tragedy in their wake. And we have had survivor after family member who's been left behind coming to hearings, came to this hearing. We had a very brave mother who came forward and exposed the deep, deep pain she is still experiencing from the suicide of her young son. She was not the first. And we have said so many other people come here and to the State House to rip the tender scabs off of wounds that will never heal with their testimony. Between the anguished New Hampshire families, the shocking attack at New Hampshire Hospital here in Concord, the massacre in Lewiston, the steady drumbeat of preventable mass shootings like the one memorialized yesterday in Parkland, Florida, and the increasing suicides right here, you might be forgiven if you are feeling numb. But we need to know how many more survivor families need to come here and testify and expose their pain. How many more bodies need to pile up before you start to feel again? It would help us if we all knew what that number is. What's the threshold? The majority of New Hampshire residents have had enough, and they want this body to take this opportunity right here, right now, to pass Senate Bill 360. It's a public safety bill that will help address the current public safety crisis. This bill addresses the gap in the New Hampshire statute that leaves families and law enforcement powerless when they see with their own eyes and hear with their own ears and experience a loved one in crisis threatening to harm themselves or others around them. We have a gap in our tools for responding to these warning signs between when someone has committed a crime or when they've been deemed too dangerous to have, where they have been deemed too dangerous to have access to firearms while that crime is being adjudicated, and the high bar of involuntary commitment to the state hospital. What is available for people who are in crisis in the gap? Families who see their loved ones' behaviors escalating in dangerous directions have only one option available to them: a wellness check by local law enforcement. Senate Bill 360 is designed to put a speed bump in front of a person who has access. And you heard from the senator from District 4 that half of New Hampshire households have firearms in their homes. This is a speed bump put in front of a person who has access to the most lethal means available to do themselves or others harm. It creates a tool for the people closest to someone suffering to prevent tragedy and get them help. It temporarily relieves a person who is demonstrating they are a danger to themselves and to all of us by temporarily standing between them and the most lethal means of doing harm to others around them. Family and household members are on the front lines of this crisis. They see when their loved ones are exhibiting warning signs and posing significant harm to themselves or to others. They see and they hear and feel the danger. They are asking for a tool to help that loved one in crisis. They feel helpless to protect them from the lethal harm that they can do to themselves or others. Significant research indicates that reduction of access to lethal means to a person at risk of harming themselves or others is an evidence-based way to reduce gun deaths. There is a callous argument that says people who are suicidal are just going to find another way to die. This is actually factually incorrect. According to Harvard's T.H. Chan School of Public Health, 9 out of 10 people who attempt suicide and survive will not go on to die by suicide at a later date. This is well established in suicidology literature. So, does this one measure eliminate 100% of the risk? No. And that's an unrealistic expectation, not applied to any other prevention efforts. Will Senate Bill 360 make an impact? Absolutely yes. Can each of you take a courageous vote to put this life-saving tool in action here in New Hampshire? Also, yes. Be courageous. A common objection to any specific measure of gun violence prevention is to apply it to a particular event and then dismiss any efficacy of the action by asserting, well, it wouldn't have prevented that particular tragedy. And I submit to you that that is uninformed and it's a lazy approach to public policy. Apply that standard to any other preventative measure we take, and we would do absolutely nothing. So let's do this. Be strong. Listen to the survivors. Listen to the citizens. We can come together and take meaningful action to prevent gun violence in New Hampshire. We can give our Granite Staters the tools they need to combat crisis. Let's take this step together, overturn the ITL, move Senate Bill 360 ought to pass, and then challenge the House to take our lead. This is something we can do now. Thank you, Mr. President.
Thank you, Senator Altshuler. Senator Abbas is recognized to speak.
Thank you, Mr. President. I rise in support of the committee's recommendation of ITL. First, I want to just address the legalities of this. The Second Amendment aside, Article 2A, the New Hampshire Constitution aside, there is a due process issue that is not satisfied, and it was brought out in the hearing and still not remedied. And I'll just explain that. After the ex parte hearing, when an order like this is obtained, to satisfy due process, you have to have the two-party hearing within a reasonable time period and have an evidentiary hearing. Yet on page 4, it says that the traditional rules of evidence will not be followed. So there is no real evidentiary hearing. So due process aside, this is not satisfied at all. The other issue is, it's in addition to firearms, I understand the Second Amendment pops up, it's a property rights issue. That's something that someone owns. When someone's denied of their property, if that order were to not be extended at the two-party hearing or just expire, the respondent doesn't automatically get their property back. So what they were deprived of, they still have to prove to the court that they can have their property back. Yet the order's gone, they took it away. And that procedure, and I'm not going to go through the whole process of what that procedure was for that type of hearing, but it was flawed in how that procedure would be performed. In addition, and we heard about other states having these laws. We heard about the state of Maine. Maine has something that they refer to as yellow flag laws, which are very similar to red flag laws. We've seen several states pass red flag laws, yet they were unable to avoid certain tragedies that were referenced in some of the testimony as well as some of the speeches today. I think the focus on mental health and how that relates to suicide is very important. And I think we did a great job in this body focusing on mental health in a bipartisan manner. But what does this bill do to address mental health? In my opinion, it doesn't address in any meaningful way, because the first time it's brought up is at the two-party hearing. So if the court thinks a person's suicidal, a reasonable time later, 7 days later, 5 days later, there's now a two-party hearing. At that point, the person may be ordered to submit to a mental health evaluation. We're not doing anything to address the fact that this person is having suicidal thoughts. It focuses solely on just disarming a person without actually offer them any other help. And there was no efforts to try to move that up the list of priorities, because to me, that's a mental health issue that should be addressed. We also talked about, this is to save lives. In New Hampshire, there is nearly 4 times the amount of deaths from drug overdoses. Yet when we try to strengthen our drug laws and the penalties for drug laws, or try to secure our northern border and the southern border, where a lot of those illegal drugs come into this country that are causing all these overdoses, we face tremendous opposition. If we really want to value life, that is a priority that I think we want to do and focus on, because those are preventable deaths. The other concern that people had with this bill is the amount of people who have standing to bring this order and the low burden of proof that one would have to reach to satisfy that burden. It's a preponderance of the evidence, the lowest civil burden of proof you can have. Again, no evidentiary hearing. There is concerns about disgruntled partners, spouses, friends, family, not friends, but household members who would potentially bring such orders during a time of conflict. And that would be in a hearing that you're not even present for. I understand there was a tragedy here in New Hampshire at a hospital. There is a bill with bipartisan support in the House. I think we should wait for that to come over here so we can give that a fair evaluation. That's HB 1711. But we can wait for that. That would address the problem here in New Hampshire that we can at least discuss and work out some of those details. But when it comes to this bill, what I will emphasize is when it looks at whether this prevents deaths, it was also conflicting evidence that the stress that this would cause, this is from testimony during the hearing, the stress that a person goes through if they're suicidal or going through a rough time. When the police come to their house, they can raid their house, take nothing but their firearms, and then simply leave, because that's all they would have the authority to do. Leaving that person alone when they're in a dark place and in a dark time, there was testimony and evidence that they actually caused suicides as well. So it's not just the policy, it's how we would implement this and how that would have impact, what collateral that would be. So I don't believe that this addresses everything that needed to be addressed. It didn't focus on the mental health to the point where I would ever support this. So please join me and support the committee's recommendation of inexpedient to legislate. Thank you, Mr. President.
Thank you, Senator Abbas. Senator Prentiss to speak.
Yes, thank you, Mr. President and members of the body. I rise in opposition to the inexpedient to legislate, and I'll keep this brief. So, first of all, I just want to say, what are we waiting for? The evidence is overwhelming throughout the nation, in a neighboring state, public health data. It all adds up, and we know that this problem exists. So I just can't understand what we're waiting for, because this is a temporary measure. This is not a permanent measure. As a paramedic, but really, so as a paramedic, I actually attended to and responded for people who had attempted and sometimes successfully completed a suicide because we were not able to resuscitate them. But I also have served the state, and I no longer do because the system has changed, as an associate deputy medical examiner. And I have been in the homes. I have been at the roadside, okay, and anywhere that I was called to where people took their lives by firearm. And many times, because part of my job, it wasn't CSI, but it was to collect the facts around, the medical evidence around this decedent, and to understand as best we could what the circumstances were that brought us to that place. I've read the suicide notes. I've talked to the family members, okay? And I can't tell you how many times that this wasn't a surprise, that they knew there was a problem, that they tried to intercede, that they didn't have a way, a method that backed them up, including a provision like this. My colleague I'm so thankful for this chart here, from District 22, Senator Abbas, I appreciate what you have had to say about whether this process is maybe not the correct one in terms of does it afford, in terms of evidence and its structure, a pathway that we need to follow. But maybe we should fix that and find a pathway that we need to follow. Because again, this is happening all around us. And I just can't understand what we're waiting for. It may be hard for you all to believe, that I, up to a certain point, resisted talking today, but I have the first-hand, on-the-scene experience that tells me that we can actually prevent deaths. We know that this works when we put time in between when somebody is at risk, okay, and their attempt. I've read the notes, I've talked to the families, I've actually seen this firsthand. So I'm begging you to think about this. This, and you've heard me talk time and time again about prevention. I think that the senator from District 24 referred to it as a speed bump. Again, you get over the bump, okay, and then you're on the other side. Okay, so we have an opportunity again to slow this down and make sure that we have done, for these number of cases, the best thing possible for them and for their family. Oh, and so I'm actually going to end it there and just ask you all to think about what exactly we're waiting for, that we hear time and time again. The evidence is overwhelming. I've had the personal and professional experience in dealing with this to come to, with great comfort and confidence, say that we can make a difference here and that we should do it. And I also feel, with respect to what Senator Abbas brought up from District 22, if the process doesn't work, then we fix the process, okay? Not dismiss this entire piece of legislation. And I appreciate all the work the committee's done on it, but I think we could do more for Granite Staters. We have an answer to this. Let's get it done. Thank you very much, Mr. President and my colleagues.
Thank you, Senator Prentiss. Senator Waters to speak.
Thank you, Mr. President. I rise a second time so that I might address some of the issues about the bill that were raised by the senator from District 22. And we all agree that due process and preservation of a respondent's rights are an important concern in extreme risk protection orders. And the bill as written does seem to ensure such protection. Let me address first the notion of relaxed rules of evidence. If you look to the bill, it states in proposed section RSA 159F39, quote, in any proceeding under this chapter, the court shall not be bound by the technical rules of evidence and may admit evidence which it considers relevant, reliable, and material. This is the exact same language found in the statute governing domestic violence protection order hearings. And relative to those domestic violence restraining order hearings, the New Hampshire Supreme Court has approved this standard, finding that, quote, it gives the trial court broad discretion in determining the admissibility of evidence and will not be reversed unless there is a clear abuse of that discretion. And so in hearings related to a person who is potentially a danger to themselves or others, as in hearings related to domestic violence protection orders, allowing a trial court judge to make reasonable determinations as to evidence admissibility without being bound by the formal rules recognize what? The urgency. There's urgency here inherent in these situations. And then secondly, the senator from District 22, the low preponderance of evidence standard. Well, let's look at that one too. If you look in proposed section 159, F4.1 here, that the court shall issue a temporary protection order, quote, if it finds by the preponderance of the evidence that the respondent poses an immediate and significant risk of causing harm to themselves or others. This preponderance of evidence standard, no, only applies to this emergency order, which can last no more than 7 days from the date of the petition. And again, this is exactly the same standard required for obtaining emergency stalking protection order under current law. So if we're trying to protect, somebody from harming somebody else, maybe the same standard of preponderance of evidence is appropriate for somebody who might harm themselves. Many states require an even lower standard of reasonable belief or probable cause. Many states also increase the burden of proof standard from the initial emergency petition to the full order hearing. But in order for the court to extend an emergency risk protection order, it must find at a hearing that the evidence reaches the higher, clear, and convincing standard. So you see what we've done here. The immediate emergency preponderance But then, when you go to that later hearing, it's an even higher standard. So in hearings related to a person who potentially endanger themselves or others, as in hearings related to stalking protections, requiring a lower standard of proof for temporary emergency orders, let's save a life, accounts for the fact that potential danger is immediate and possibly deadly. So I think we recognize rights, and I think that this bill offers, as has been proved valuable in existing legislation, those same standards. Thank you, Mr. President.
Thank you, Senator Waters. Senator Carson to speak. Senator Abbas, a question? To speak.
Thank you, Mr. President. I can just address some of the comments that are made. I understand when people want to compare a red flag law to a domestic violence restraining order. It may seem logical, but it's not. And the reason for that is in a domestic violence situation where you get a restraining order, you have someone who's been a victim of a violent crime. So the entire level of scrutiny is different. You're in a completely different set of circumstances because the allegations are not that a crime may be committed, a crime has been committed. And you're trying to protect that victim of that violent crime from suffering further abuse by giving them that order on an emergency basis. With what is presented in this policy, there's no crime that's been committed. It's just speculating that they believe a crime is to be committed. That's a different analysis altogether. And to do that and to rely on hearsay evidence and to rely on, without having any other evidentiary rules, I mean, that's what the Salem witch trials were. No evidence, no rules of evidence applied in hearings like that. That's why it's very important. All right, we're talking about a case here where no one violated any law. And that's what, they still can have their property taken from them and they have their Second Amendment rights restricted. That's the major difference. In respect to working on this, many of these points I brought up in my first term in the House when I saw a bill like this 2 terms ago. Raised the same issues. And I get presented with the same bill. Same issue, same evidentiary hearing problem, same property rights issue, same due process issue. I see the same mistake over and over again. So I point these out as I believe in public service, and I always speak objectively when I see a policy, whether I support it or not. But I don't see many of those concerns being addressed in this draft either. Thank you, Mr. President.
Senator Whitley to speak.
I rise because I have to address the unfair comparison to this bill to the Salem witch trials. What we are talking about here are the necessary steps to protect life, right? And in regard to the rules of evidence, this bill nowhere says that the rules of evidence don't apply at all. What it says is that it is relaxed. So in hearings related to a person who is potentially a danger to themselves or others, just as in hearings related to domestic violence protection orders, a trial judge has the discretion here, right? A trial judge has the discretion to make reasonable determinations as to the admissibility of certain evidence. That is very common. We're not saying that this is a kangaroo court, right? This is still before a trial judge. They are still going to make a determination of the admissibility of evidence. And so I want to be very clear about that. Thank you, Mr. President.
Thank you, Senator Whitley. And now our final speaker, I believe, Senator Carson.
Thank you, Mr. President. Mr. President, I think every single person in this body can agree that suicide is a tragedy. It is a true tragedy. Some of us have had our lives touched by friends and family members who have committed suicide. For me, it was my uncle in the late 1960s. He was a veteran. He had served our country honorably in the Korean War. And he was a member of a unit that was stationed at the Chosin Reservoir. And if you know anything about the Korean War, those soldiers ended up being called the Chosin Frozen because of the deprivations they suffered during that particular time. And he came home and he had frostbite in his hands and his feet. And he struggled for many years to deal with that. Now again, late 1960s, medicine. We didn't have a lot of the painkillers that were available today for these folks. And it got so bad that he started drinking. And when he started drinking, he lost his job. And one day he came home and he decided to end his life. And that's exactly what he did. And he left behind a family who was devastated, his wife and my 3 cousins. It touched all of us. So I understand the tragedy of suicide. So let's talk about this bill a little bit, because it makes a number of assumptions. And let's talk about what an ex parte order is. It's an emergency order. You are at a situation that is extremely acute. Now, what happens to the individual who's being accused? Are they present during an ex parte hearing? For the most part, they are not. Do they have an attorney representing them? Usually not. But what we're asking judges to do is to judge someone's mental health status. Are judges qualified to do that? Are you going to be bringing in mental health professionals to discuss someone that perhaps they haven't even looked at? What about the rights of the accused? Where do they come in? This is one reason why when we talk about ex parte orders, we need to be very, very careful about what we're actually doing. In fact, we've had some correlations made today between this bill and the domestic violence ex parte hearings. Just so everyone knows, there is currently a case in front of the U.S. Supreme Court on the constitutionality of ex parte orders in domestic violence cases and the taking of someone's guns, their firearms. So that one's going to be interesting to see when the court issues a ruling, which I hope is going to be this spring. This is one reason not to vote for this bill, because we don't know what they're going to say. There's a couple of other things that I'd like to point out. I heard in the testimony here this morning, or I should say this afternoon, that people working together. This was something that was brought up during the public hearing. So, Mr. President, you had people who were gun rights advocates and people who were advocates for this law. And when the gun right advocates came up, I asked them, did you get together? Were you invited to meetings? Did you have discussions about this to bring the gun community together with the folks that are really concerned about this bill? The answer universally was no. No. And I want to make this very, very clear. We're talking about extreme protection orders, but this is a red flag bill. This is exactly what this is. And it makes a lot of presumptions about an individual's mental health status. And we need to be very, very careful when we do that. Because what this does is it takes away an individual's constitutional rights. We had a great discussion this morning about constitutional rights. But unreasonable search and seizure, their Second Amendment right, right to an attorney, all of those, in the name of preventing suicide, we're being asked to overlook an individual's constitutional rights in order to keep them safe. And we have to weigh that. That's what we're being asked. Is it worth someone losing their constitutional rights? A few years ago, my good friend from District 4 and I worked on a bill. It was Senate Bill 244, because the issue of mental health came up and gun use. That's when we really started hearing a lot of conversation about this. The first part of the bill we couldn't work with because everyone was all over the place. But the second part of the bill created a method for an individual who had a court remove their guns because of a mental health illness, usually because they were involuntarily committed. But there was no path for them to get their guns back once they were back to themselves. Unfortunately, we couldn't get that passed, but that is still the case. So they're taking away your guns. Oh, and by the way, it doesn't distinguish between your guns and somebody else's guns. If they're in the house, they're going to take those too. So someone who's done nothing wrong, absolutely nothing wrong, can lose their Second Amendment rights because someone has made a complaint that they think someone is mentally ill. And Mr. President, we cannot be naive enough to think that people will not make those claims frivolously. We know this happens. But this is extremely important because it is a constitutional right. Mr. President, there were a couple of the points that I wanted to make, and some of them I believe have already been made, but I'll just reiterate. This bill relies heavily on suicide protection. Do you really think red flag laws help people? Talk to the people of Buffalo, New York. New York has a red flag law. How many people were killed there? Didn't stop them. My good friend from District 22 brought up the Lewiston issue. What happened there? They had yellow flag laws. The family complained to the police that this person had issues. Nothing happened to him. And they knew this individual. And just last night in Washington, D.C., 3 police officers were shot. Washington, D.C. is also a red flag zone. So please tell me how it's going to prevent it. Shootings, suicides. I think if we could bring back every single person who committed suicide and ask them, do you regret what you did? I guarantee you probably every single one of them would say yes. Because there is another path. But taking away someone's Second Amendment rights because you think they're going to do something wrong? Do we want to go down that road? I know people vilify guns. That's just the society we live in today. But this morning I watched a news interview with a minister. And in Washington, and he talked about this is about choice and what people choose to do. And that's what we need to look at, as well as the mental health issues. So what have we done for mental health here in New Hampshire? Well, we gave $134 million for Medicaid provider rates, which helped our community mental health centers. We gave $5 million for crisis stabilization services, $2 million in funding for recovery-friendly workplace initiative. We extended the ability to use $6 million for transitional housing beds and expand support for behavioral health crisis response initiatives. We funded a new youth development center at Hampstead Hospital. We provided an additional $16.5 million to support family resource infrastructure and to support residential treatment provider rates as a component of the system of care for a total of $66.9 million. And we also spent $1 million for an early childhood mental health consultation pilot program for the youngest of our state's children. We continue to support mental health services in the state of New Hampshire. And Mr. President, I would dare to say we are going to continue to support mental health services in the state of New Hampshire because we know we have people in the state of New Hampshire that need these services. They really and truly do. And we support those services. We heard some discussion about the rates of suicide here. Quite frankly, we prevent suicide by investing in mental health education, which we have, and treatment in our state. So individuals contemplating suicide can get the help they need. If someone threatens that they're going to hurt themselves, why isn't the first thing you do pick up the phone and call the police. Call the police and tell them you have someone in your home who is struggling and needs help. The police are there to help. You can take them to a hospital as well, if you can get them to go. Because you can't force somebody. If you are that concerned, you can get that person involuntarily committed to our state hospital where they will be evaluated by a mental health professional and hopefully set them on the path to recovery. According to the CDC, in 2021, over half of our states, the states in our country, have higher suicide rates than New Hampshire, and some of those states are red flag law states as well. New Hampshire had 233 deaths by suicide in 2021 and 441 deaths by drug overdose. Yet attempts to stop drugs from crossing our northern and southern borders and increasing penalties for those who sell drugs and cause these deaths are opposed by some people here in this chamber. Suicides, again, are not only tragic for families and those that take their lives, but is that a reason to infringe upon constitutional rights in the guise of suicide prevention? Though most deaths in New Hampshire involving a gun are suicides, according to United Against Gun Violence, less than half the suicides in New Hampshire involved a gun. I'll conclude my testimony at this point, Mr. President. I think we've had a really great discussion this morning. I want to thank everyone, and I would hope that they would support the committee. Thank you very much.
Thank you very much, Senator Carson. So the hour is getting on. We have a hard deadline of being back here at 1:10 for the governor's address. I still have to speak Senator Altschiller. I have Senator Avard, Senator Altschiller, Senator Whitley for questions, and Senator Rosenwald for speaking. Okay, so we will resume right after the governor's address, 15 minutes after the conclusion of the governor's address, and I'll recognize Senator Altschiller first. Okay, so we will be in recess till 1:10 promptly. Thank you for being prompt. The Senate will be attentive to the clerk.
Thank you, Mr. President. The House of Representatives is ready to meet with the Honorable Senate in joint convention for the purposes of hearing the State of the State addressed by His Excellency Governor Christopher T. Sununu.
I recognize Senator Carson.
Thank you, Mr. President. Resolved that the Senate is ready to meet with the Honorable House of Representatives in joint convention for the purpose of hearing the State of the State addressed by His Excellency Governor Christopher T. Sununu.
All in favor, please say aye. Aye. Any opposed? The ayes have it. The Senate will recess in joint convention and line up over there. The Senate will please come back into session, and we will resume our debate on Senate Bill 360. And I indicated that Senator Altschiller would be the first to speak in the resumed debate. So I recognize Senator Altschiller.
Thank you, Mr. President. So I want to address some of the assertions that were made here before we took a break for lunch. First of all, we heard an assertion that Maine has a yellow flag law and it didn't do anything. Well, I have a pen, and if I don't click it and put the ink on the paper, it doesn't do anything. This is a tool. The yellow flag law was a tool, and the law enforcement agencies chose not to use it. So when you don't use a tool at your disposal, it's not going to work. So I assure you that since the Lewiston shooting, there have been innumerable meetings, conversations with the community, and discussions at the Maine legislature to encourage the use and of the law that they have, and they are looking to bolster it. They're actually doing something. I am so glad to hear that my colleague from District 14 and the governor today gave extensive lists of programs and money and initiatives and collaborations that we have engaged with as a state to address opioid addiction and mental health crises. And interesting that we don't apply the same, well, that program's not going to solve the mental health crisis to each and every one of them, like you are being asked to do with the extreme risk protective order. Will it solve every single problem? No. Just like every other public health policy needs to work in collaboration, and it needs to be available to be used. We also heard an assertion that extreme risk protective orders increase suicide and that it drives people to suicide. That is a preposterous assertion that was not supported in committee with a single bit of source to back it up. And also about who supports this and who's been included in the conversation. This has been a multi-year effort. And as a matter of fact, when we began this, we began to build a coalition, and we had dozens of legislators, input from the New Hampshire Coalition Against Domestic and Sexual Violence, input from the National Alliance on Mental Illness New Hampshire chapter, input from the ACLU, input from the Chiefs of Police Association, input from first responders like our colleague from District 5, input from Moms Demand Action, input from Gifford's Promise, input from Everytown for Gun Safety, and hundreds of gun violence prevention advocates. But if you remember, during the hearing, and as was just mentioned a little while ago, there was a question posited to just two people testifying in opposition to this bill, and the question was, were you consulted in the drafting of this bill? And I might have laughed right there if I wasn't so horrified. One of the people that was asked if they had been included in this very serious public policy conversation is a person who has a disgusting habit of referring to me as Deborah Alch Hitler on social media and on hate blogs. So no, wasn't my first choice of people to come to the table for a serious conversation. Another one proudly represents a group that calls themselves a no compromise gun lobby and regularly puts out emails and other online alerts calling extreme risk protective orders objectively ineffectual. This is the opposition who thinks they should be at the table having serious public safety discussions, it would be laughable if it wasn't so offensive.
Please. Thank you, Mr. President. I'm really not sure how to do this, but my good friend from District 24 is denigrating and criticizing members of the public who came to testify in front of us. I don't believe that that's appropriate, and I would ask that she stop doing that. Thank you very much, Mr. President.
Mr. President, point of order. I have denigrated no one, and I have quoted them directly, and they put themselves out to us. So I'm taking what they brought to the table. And so if this is how they want to present to us as legislators, okay, let's take people at their word. Let's take people at their presentation. So
The public record that,
I am.
with no names mentioned, you're recognized to proceed.
Thank you. We also had an assertion from my colleague in District 14 that people in crisis should just call the police. Call the police, right? They're here to help. Call them. Here's what happens when you call them, because here's what happened to my constituent in Exeter, who testified and I brought her testimony to the committee. You can read it. Her son was experiencing a mental health crisis, and the police were brought in. The Exeter police came to their home, talked to this young man, and because these particular police were trained in dealing with people who were experiencing mental health crises, although we now know not everyone on the force was, we just had a moment of luck in this moment. They had a conversation with him, and with the help of his parents, convinced him to relinquish his firearms to them. The Exeter Police Department had no problem taking the guns, bringing them to the Exeter Police Department, and holding them, because we actually have procedures in place for holding on to firearms at our local police departments. And this young man was able to get some help. He was actually hospitalized for a couple of months. He came back out, and he chose not to go to the Exeter Police Department and get his firearm because he was afraid, and disclosed this, that it might raise a red flag. So what he did was he went to his bank account and he took an enormous amount of money out, and that actually raised a red flag. And his mom saw that money come out of the account and asked him, "What are you doing? What do you need the money for?" "Oh, well, my friends had to I had to spot my friends the rent," and so there was a big, long explanation that had no basis in truth. And then he got himself to a firearm dealer, paid cash for a firearm, took that, drove to Dover, and died by suicide in the parking lot very close to the Dover Police Department. And so the Dover police and first responders were there to clean up after this. And there were multiple attempts between the first time and the time he actually died by suicide for law enforcement intervention. And the police had come on multiple occasions, and some police were not as adept at dealing with mental health issues, and there was nothing the parents could do. Nothing they could do. They wanted the ability to go to court and get his firearms taken away, and his ability to go get more impeded, because that's what he could still do. He didn't have the first firearm. There was nothing stopping him from going to get some more. So that testimony is in the record. So when you call the police, and I will tell you, in my town, We actually have an issue happening right now, and our police department have been called multiple times and have told our citizens we are doing all we can, but we don't have any tools for this. We can do drive-bys. We can watch people's social media. We can try to intervene if something crosses the line, but until this person commits a crime, like say, shooting people, like happened in Lewiston, there's nothing they can do. They need this tool. Families are asking us for this tool, and serious people who seriously understand that we have a crisis on our hands know that we have to take some action. This is our opportunity to take some real action and pass this extreme risk protection order law so that we can get in front of people who are doing harm to other people and themselves. Thank you, Mr. President.
Thank you, Senator Altshuler. Senator Rosenwald, did you wish to speak?
Just briefly, Mr. President, thank you.
You're recognized.
My seatmate and fellow knitter said before lunch that this bill would ask judges to determine someone's mental health status and then take away their constitutional rights. And I just wanted to remind us all that judges do this all the time when they're asked to do an involuntary commitment and take away someone's rights for a longer period of time, committing them to the state hospital. And I might add that in those cases, judges are making these determinations over the telephone. They don't even see the person. They don't even have a video link. They are making a determination of someone's mental health over the telephone. Thank you.
Thank you, Senator Rosenwald. I have Senator Avard for a question.
Senator 14.
Senator Carson. Senator Avard.
Senator Carson, thank you for taking my question. This is really brief, but our esteemed colleague from District 24 did bring this up, and I just wanted to follow up a little bit on it. She mentioned that New Hampshire is one of the most safest places in the country. Mm-hmm. I believe the governor kind of reiterated that. Why do you think that is?
Thank you. Thank you for the question. I think it's because of laws that we've put into place protecting the Second Amendment, right? I think because we did not go down the route like some other states in defunding the police. I think those are two very critical issues that are keeping us the safest state in the nation.
Thank you.
Senator Birdsall for a question? No question. Senator Gannon for a question.
Thank you, Mr. President. My friend, good senator from 23, if you could take my question. 22, I'm sorry, I'm 23, wake me up. Wow, it's only 2 o'clock. Would you believe, or do you recall even, that in our testimony we heard from the Women's Defense League of New Hampshire, she said, regarding to red flag laws, that the Indiana law has not worked and suicide murders have increased. Do you recall that?
What I recall was that there was a lot of conflicting evidence on the actual effectiveness of red flag laws, and the reason for that is there's a presumption made in the stats that if the order's issued, that it actually prevented a suicide. However, there was so that's not really conclusive evidence that it prevented something, but there was also evidence that in some states, not every state, the suicide rates didn't go down, but there was also evidence presented by a doctor who testified, and I gave the doctor's testimony a tremendous amount of credibility, and it's highlighted on page 8 of the committee report, because that witness testified in support of the bill passing, but mentioned Connecticut, where it was believed that although their laws may have prevented 128 suicides, it may have contributed to 140 non-gun related suicides. So there was some evidence of that presented, and the reason that was highlighted in that was just to provide objective stats to the committee, so I really gave that credibility. So it wasn't clear that it actually would successfully prevent suicides in a
Thank you, Senator.
Thank you, Senator Abbas and Gannon. The question is on adoption of the committee amendment. And we're still in the mode of further discussion. Senator Carson.
Thank you, Mr. President. I feel compelled to stand because of some things that have been said. I want to make it very clear, at no point during the public hearing was the good senator from 24, her last name, cast in any dispersions. We don't allow that in Senate Judiciary, and if someone had done that, they would have been gavelled. So that did not happen in Senate Judiciary, and it's not a part of the record. There was also some testimony from, some comments made this afternoon about 2 individuals who were asked that are members of gun groups, and I want to clarify that. The first person is the vice president of the Gun Owners of New Hampshire, a very well-known gun advocacy group, and he was asked by myself if he had been contacted concerning this bill. He was contacted not as an individual, but as the vice president of this organization. He answered, no, he did not. He was not contacted. The other person who testified, I specifically asked concerning the organization this other person represented. It was not him, it was the organization, and they said they were not contacted either. The reason why that question was asked, Mr. President, was because we had testimony that said, well, we've worked together with everyone in other states to pass legislation. That did not happen here in New Hampshire. I want to be very, very clear about that. Thank you very much, Mr. President.
Thank you, Senator Carson. The question is on adoption of the committee recommendation of inexpedient to legislate. Seeing no further discussion, if you're in favor of that motion, you would say yes. If you are opposed to the motion of inexpedient, you would say no. Everybody is here.
Senator Susie, but I didn't.
Senator Susie has asked for a roll call. I'm assuming it's been seconded. Thank you, Senator Birdsall. The clerk will please call the roll.
Senator Gendreau.
Yes.
Senator Lang.
Yes.
Senator Waters.
No.
Senator Prentiss.
No.
Senator Gray.
Yes.
Senator Innes.
Yes.
Senator Ward.
Yes.
Senator Ricciardi. Yes. Senator Fenton.
No.
Senator Chanley.
No.
Senator Avard.
Yes.
Senator Rosenwald.
No.
Senator Carson.
Yes.
Senator Whitley.
No.
Senator Murphy.
Yes.
Senator Pearl.
Yes.
Senator Susie.
No.
Senator Birdsall.
Yes.
Senator D'Alessandro.
No.
Senator Perkins Kwoka is excused. Senator Abbas.
Yes.
Senator Gannon.
Yes.
Senator Altshuler.
No.
And Senator Bradley.
Yes. The ayes have it, 14-9. Senate Bill 360 is found inexpedient to legislate. The Senate will please be attentive to the clerk.
Thank you, Mr. President. The Committee on Judiciary, to which was referred Senate Bill 567 FN, an act relative to protecting and expanding access to abortion medications. Having considered the same, the committee recommends that the bill is ought to pass with an amendment by a vote of 3-2. Senator Carson for the committee.
Senator Carson.
Thank you, Mr. President. I move Senate Bill 567 FN ought to pass with amendment. This bill would have directed the Department of Health and Human Services to protect and expand access to critical medications for reproductive health that are approved by the Food and Drug Administration. The committee amendment would establish a committee to study the availability of in New Hampshire of substances used to induce the termination of pregnancy. This bill, as originally written, prompted numerous concerns as to how the Department of Health and Human Services would even accomplish the directives of the legislation, as currently there is a case in front of the Supreme Court of the United States that will determine the legality of certain abortion medications. The study committee that would now be created through the amendment is a reasonable compromise. The committee will study the availability of these medications, including but not limited to, and I completely apologize to everyone because I have a lot of difficulty pronouncing this word, mifepristone and misoprostol, and will not put DHHS potentially out of compliance with federal law. For these reasons, a majority of the Senate Judiciary Committee asks for your support on the motion of ought to pass with amendment on Senate Bill 567 FN. Thank you, Mr. President.
Thank you, Senator Carson. The bill is now on second reading. First order of business is the committee amendment. Any discussion on the committee amendment? Senator Whitley.
Thank you, Mr. President. I would ask that my colleagues vote down the committee amendment. Senator Carson and I can bring forward a floor amendment. Thank you, Mr. President.
Is there any further discussion on the committee amendment? Seeing none, are you ready for the question? All in favor of the committee amendment say aye. All opposed? No. The noes have it. Very good. Senator Carson, you are recognized to introduce Amendment 714.
Thank you very much, Mr. President. I'd like to introduce floor amendment number 2024-0714S. Mr. President, this amendment accomplishes basically the same thing. I've worked with my seatmate and colleague and friend to come up with a bipartisan compromise that I think is going to work on this. So I would ask the body to please support amendment number 0714S. Thank you.
Thank you, Senator Carson. Is there any further discussion? Senator Whitley.
Thank you, Mr. President. I rise in support of the floor amendment and want to thank my colleague from District 14 who is always willing to work with me to reach consensus in a bipartisan basis, and I truly appreciate that and her work together with me on this floor amendment. Thank you, Mr. President.
Thank you, Senator Whitley. The question is on adoption of floor amendment 714. Are you ready for the question? All in favor, please say aye. Aye. Any opposed? No. The ayes have it. The floor amendment is adopted. The bill is on second reading and open for further discussion or amendment. Seeing no discussion, the question is on adoption of ought to pass as amended on Senate Bill 567. Are you ready for the question? All in favor, please say aye. Aye. Any opposed? No. The ayes have it. The motion is adopted, and Senate Bill 567 is ordered to third reading. The Senate will please be attentive to the clerk.
Thank you, Mr. President. The Committee on Judiciary, to which was referred Senate Bill 571FN, an act relative to requiring a background check prior to any commercial firearm sale. Having considered the same, the committee recommends that the bill is inexpedient to legislate by a vote of 3-2. Senator Gannon for the committee.
Senator Gannon.
Thank you, Mr. President. I move 571FN inexpedient to legislate. This bill would require commercial firearm sales or transfers in the state to be subject to a criminal background check and provides a criminal penalty for a violation. This bill would further provide a process for a commercial sale of a firearm where neither party to the prospective transaction is a licensed firearms dealer. This piece of legislation is nothing more than an infringement on our Second Amendment rights, as it makes it more difficult for law-abiding citizens to acquire guns legally, places more burdensome regulations on our licensed gun dealers, who were not even consulted in drafting this legislation. These dealers told us they would not want to do the NICS background checks. This bill would not solve the problem it seeks to fix. Instead, all it will do is stop law-abiding citizens from acquiring guns. It will not stop criminals. In fact, 90% of gun crimes are carried out with illegally sold guns. Guns used in crimes come from criminals, not the law-abiding citizens this legislation targets. For these reasons and more, a majority of the Senate Judiciary Committee asks for your support on the motion of inexpedient to legislate on SB 571FN. Thank you, Mr. President.
Thank you, Senator Gannon. The motion is inexpedient to legislate. There is discussion. Senator Altshuler.
Thank you, Mr. President. I rise in opposition to this committee amendment. Senate Bill 571 is a public safety bill. This is a bill that will significantly enhance the safety and well-being of our communities by instituting background checks for commercial sales of firearms here in New Hampshire. The reality is that firearms sometimes fall into the wrong hands, posing a threat to public safety. And although we cannot stop every instance of that happening, that is not an excuse for inaction. It is not an excuse to throw up our hands and say, well, we can't prevent a prohibited person from getting a firearm. Yes, we can try. Fortunately, we have an opportunity, once again, to do some good, close a loophole, mitigate some potential damage by passing Senate Bill 571 and ensure appropriate and robust background checks are taking place. Senate Bill 571 provides a carefully crafted framework with key definitions, processes, and safeguards that balance our Second Amendment rights with public safety. It does not restrict responsible gun ownership. It only ensures that those who want to engage in commercial firearm transactions do so in a manner that prioritizes the safety of our communities. Requiring background checks on all gun sales is proven to reduce gun violence. State laws requiring background checks for all handgun sales by point of sale check and/or permit are associated with lower firearm homicide rates, lower firearm suicide rates, and lower firearm trafficking. When Connecticut passed a law requiring background checks, both for a handgun purchase permit and at the point of sale, its firearm homicide rate decreased by 40%, and its firearm suicide rate decreased by 15%. Those are lives. By mandating the involvement of licensed firearm dealers in commercial sales, we add an extra layer of accountability to the process, requiring dealers to conduct background checks, comply with federal, state, and local laws, and facilitate the transfer of firearms only if the transaction is lawful. Not only will this protect our citizens, it will also uphold the integrity of responsible firearm ownership. Importantly, Senate Bill 571 will not be a burden on consumers trying to access a federally licensed dealer, because in New Hampshire alone, there are 613 federally licensed dealers. By comparison, we only have 136 supermarkets in the whole state. So rest assured, guns will continue to be easier to find than a fresh pineapple. Senate Bill 571 also outlines penalties for violations and mandates that local law enforcement agencies report such violations to federal authorities. This ensures that any breaches of the law are addressed swiftly and appropriately, creating a deterrent for those who might consider engaging in illegal firearm transactions. Finally, and I want to stress, this legislation is a commitment to the safety and security of our communities. It strikes a balance between individual rights and a collective well-being, providing a framework that ensures responsible firearm ownership. This speaks to being, as the Second Amendment prescribes, well-regulated. This is a reasonable and balanced approach to addressing the reality of our world today. A world full of mass shootings, skyrocketing suicide rates here in New Hampshire, a populace that is continuously barraged with a slew of charged political rhetoric and even calls for civil war. So let's take a step back from this. Take a step back and be serious. A sale of a firearm at a licensed firearm dealer includes a background check right now. A sale of a firearm between two supposedly law-abiding adults should also include a background check. It is good gun violence prevention policy. This is not an attempt to disarm the populace. This is not an attempt to infringe on the rights of law-abiding citizens to have access to firearms. This is simply a bare minimum piece of public safety infrastructure policy that will help us take a significant step towards a safer and more secure New Hampshire. Thank you, Mr. President.
Thank you, Senator Altshuler. The next person to speak will be, please, Senator Fenton.
Thank you, Mr. President. I rise in opposition to the committee recommendation on Senate Bill 571. As my colleague said, Senate Bill 571 does not infringe upon the rights of law-abiding citizens to own firearms. It is a bill that solely introduces responsible measures to prevent firearms from reaching individuals who, by law, should not possess them. I am a gun owner, and I hold my Second Amendment rights at high value. I understand the need for protection and the security that gun ownership provides, but I also recognize that our rights as citizens must be balanced with one another. The Second Amendment and gun safety laws can coexist with one another, which is what our citizens want. In fact, 85% of New Hampshire gun owners support background checks for all gun sales. This is an astounding majority, so why wouldn't we act upon this? Why wouldn't we work collectively to strengthen our commitment to preventing firearms from reaching individuals with a history of criminal activity, domestic abuse, or mental illness? As a state, we have declared that these individuals should not have the ability to possess a firearm, so why would we not act to ensure that they cannot easily access them? We will never be able to prevent every gun from entering the hands of a prohibited person, but we can effectively mitigate that reality by requiring background checks to identify those individuals who are. The everyday reality that is taking place in our state is that individuals are transferring or selling firearms to individuals that they moderately know without conducting a background check, and that is unacceptable. Background checks need to be conducted to ensure that we are doing what we responsibly can to prevent firearms from entering the hands of prohibited persons. This bill also has exceptions for instances of transferring antique or permanently inoperable firearms, appropriately tailoring the bill. Furthermore, my colleague from District 24 presented an amendment to the committee where she introduced the bill, further expanding that exception by carving out immediate family members, and bear with me, including spouses, parents, step-parents, children, stepchildren, siblings, step-siblings, grandparents, step-grandparents, grandchildren, step-grandchildren, great-grandparents, step-great-grandparents, great-grandchildren, and step-great-grandchildren. The only thing we're missing is my twice-removed cousin's dog walker. These exceptions are appropriate and should be in place, but without the support from you all, we cannot move forward with this balanced and measured approach for our citizenry. Mr. President, we have a responsibility to our citizens to act in the interest of their safety. And I, like my colleagues, refuse to simply give up on our efforts to engage in gun violence prevention, and I hope you will refuse to do so as well. Thank you, Mr. President.
Thank you, Senator Fenton. Senator Carson is recognized to speak.
Thank you, Mr. President. A lot of what we've said about guns, we've had great conversations about today. But I find this bill to be really kind of troubling, because I specifically asked the question about whether or not these dealers were consulted in putting this bill together. Because what we're doing is we're saying, if I decide I want to buy a gun and gift it to my husband for his birthday, I have to go through a federal firearms dealer. They weren't consulted about whether or not they even want to do something like this. And I think that is one of the fatal flaws in this bill. We had a lot of really good testimony about this. Specifically that going through this type of registration, background check, whatever you want to call it, isn't going to prevent crime. People will, if it's the law, law-abiding New Hampshire gun-owning citizens will do this. It's a question about whether or not the firearm dealers even want to do this. Can they charge a fee for their work? This bill doesn't speak to that. Can they decline it? This bill doesn't speak to this. They just have to do this. So, Mr. President, for those reasons, I do believe that this bill is not ready, probably needs a lot more work, and I would just ask the body at this point to support the committee report. Thank you.
Thank you, Senator Carson. Senator Pearl for a question.
Thank you, Mr. President. Member of District 23. I got you right this time.
I'm waking up.
Thank you for taking my question. So as
Thank you.
I'm listening to the testimony here, I'm kind of compelled to ask this question. If I decide to buy a gun that I want to gift to my son for Christmas, would I be allowed to do that with this bill?
See, now that's a very interesting question. I can tell you why. If everyone goes to page 3 on the amendment, if you were under 18, line 6, under 18 you could give, if he was under 18, I don't know how old your son is.
He's a little over 18.
Okay, so you could not. You would be denied because in the beginning of the part it says, if the status, you don't really know his eligibility. You don't know everything. Like my son's in Philadelphia, I don't know what goes on out there. For me to properly know and to give him the gun, I would have to 100% ascertain that he's under a NICS, that he could be eligible for this gun. So under 18, you could give it to him. Over 18, you'd have to do a NICS check because you would not be able to ascertain 100% that he was eligible.
Thank you.
You're welcome.
The motion is inexpedient to legislate. Is there any further discussion? Senator Carson.
Thank you, Mr. President. Again, I rise to ask the body to support the committee on this. There's a few points that I think we really need to really consider when you think about this legislation. We had testimony. Background check laws do not prevent criminals from getting guns. They're going to find a way to get it. This is only going to affect law-abiding New Hampshire citizens. We know that criminals do not get guns through legal means. Law-abiding citizens get guns through legal means. And therefore, this law would merely infringe upon the constitutional rights of law-abiding Granite Staters. New Hampshire has one of the lowest firearm mortality rates in the entire country. Firearm dealers were not consulted on this bill, and I think their voice would be a very important voice. But again, Mr. President, this bill is unnecessary. I will repeat it again. As I said earlier, according to U.S. News, we are the safest state in the nation because we protect Second Amendment rights, we do not defund the police, and we do protect qualified immunity. Thank you, Mr. President.
Thank you, Senator Carson. The motion is inexpedient to legislate. Seeing no further discussion, I believe a roll call was called for by Senator Soucy, seconded by Senator Avard. The clerk will please call the roll.
Senator Gendreau.
Yes.
Senator Lang.
Yes.
Senator Waters.
No.
Senator Prentiss.
No.
Senator Gray.
Yes.
Senator Innes.
Yes.
Senator Ward.
Yes.
Senator Ricciardi.
Yes.
Senator Fenton.
No.
Senator Chanley.
No.
Senator Avard.
Yes.
Senator Rosenwald.
No.
Senator Carson.
Yes.
Senator Whitley.
No.
Senator Murphy.
Yes.
Senator Pearl.
Yes.
Senator Soucy.
No.
Senator Birdsell.
Yes.
Senator D'Alessandro.
No.
Senator Perkins Kwoka is excused. Senator Abbas.
Yes.
Senator Gannon.
Yes.
Senator Altschiller.
No.
Senator Bradley.
Yes. The ayes have it, 14-9. Senate Bill 571 is found inexpedient to legislate. The clerk, the Senate, will please be attentive to the clerk.
Thank you, Mr. President. The Committee on Judiciary, to which was referred Senate Bill 575 FN, an act relative to legal protection for legal New Hampshire abortion and contraception care. Having considered the same, the committee recommends that the bill is inexpedient to legislate by a vote of 3-2. Senator Abbas for the committee.
Senator Abbas.
Thank you, Mr. President. I move SB 575 FN inexpedient to legislate. This bill would provide various legal protections related to the performance of or support of legal reproductive health care services, including a prohibition against extraditing certain individuals for legally protected health care activities, and prohibitions against the government officials or police agencies from cooperating with any out-of-state investigations into legally protected health care activity, absent court-issued subpoenas or warrant, amongst others. This bill allows for a so-called shield law for women who come into the state of New Hampshire to have an abortion procedure. However, the way the bill is written is rife with issues. It presents legal concerns as a state government can regulate interstate commerce, but only the federal government can regulate interstate commerce. Not only does this bill have too many inconsistencies with federal law to make it acceptable, but the committee did not hear evidence of one such legal case for cross-border action. Furthermore, the bill's expansive definition of, quote, reproductive health care services is all-encompassing and could potentially allow for all health care being shielded with this bill, creating numerous unintended consequences that were never thought of during the drafting of this bill. For these reasons, a majority of the Senate Judiciary Committee asks for your support on the motion of inexpedient to legislate on Senate Bill 575-FN. Thank you, Mr. President.
Thank you, Senator Abbas. The bill is on, the motion is inexpedient to legislate. The bill is on second reading, open to further discussion. Senator Susi is recognized, but Senator Gray, can you come up here for a moment?
Thank you, Mr. President. Mr. President, I rise in opposition to the committee's recommendation of inexpedient to legislate on Senate Bill 575. 575 provides protection for reproductive health care services, including for patients traveling to New Hampshire from states where abortion is restricted or banned. With this bill, we would ensure that individuals will have access to essential care in New Hampshire without fear of retribution from their own home state. We're well aware that since the Supreme Court overturned Roe v. Wade and states became responsible for abortion protections, a patchwork of laws have been passed across the United States. Some states have strengthened their protections to promote abortion access, while others have criminalized abortion access or facilitation, or subjected providers who perform abortions to civil and professional liability. In a post-Roe country, borders and jurisdiction will become the central focus of the abortion battle. This is because innovations in the delivery of abortion care enable some to receive care entirely online and transcend state boundaries. This puts us in an uncharted territory for patients and providers, and therefore it's necessary that we provide clarity and clarify for everyone providing and accessing care in New Hampshire what can and can't be done. Many states like Missouri have already tried and are continuing to try to restrict patients from accessing abortion in other states. Further, the Texas abortion ban includes a bounty hunter provision, allowing essentially any individual anywhere to seek a civil lawsuit against anyone who aids and abets an abortion, a provision that has not been struck down by the Supreme Court. The lack of clarity in our current law and the potential legal action that may be implemented at any point against individuals in New Hampshire creates an incredibly chilling effect on a patient's ability to receive reproductive care, and also on the healthcare provider industry overall. New Hampshire, as we know, is already facing significant shortages of healthcare providers, especially when it comes to reproductive health care. Right here in this body, many of our members have proposed legislation which we've supported, trying to assist in areas particularly in reproductive and maternal care because we know we have a shortage. But since the abortion ban was first introduced, we've heard from providers from the start, providers, pre-med students across our state, that legislation like criminal penalties that we have in New Hampshire's abortion ban and the lack of protection from out-of-state prosecution has a chilling effect on those who are looking to practice reproductive care in New Hampshire. One of our own former members, who is here on behalf of his employer, even testified It's not hyperbole to say providers in New Hampshire are scared. They're scared to do their own job. Just last year, with the closure of the Frisbee Memorial Hospital, occurring 2 years earlier than planned, we saw the 11th hospital in the state close down their labor and delivery services since 2000. 11 since 2000. Birth rates are continuing to rise in New Hampshire, but our ability to provide appropriate health care is actually declining. And we have the potential, and I think in some areas of our state, we actually have birthing deserts where people can't get the prenatal care, the birthing services, and the postnatal care that they so desperately need to have. Currently, there are only 15 hospitals and 6 freestanding clinics with midwives that are now delivering babies in our state. There are maternity deserts that stretch across our state. It's not unique to one geographic region, but it's especially true in the North Country, putting the health and safety of those women at risk. This is something that we just can't ignore. Bills like Senate Bill 575 that give providers clarity and that we show that we as a state will not allow other states to come in and prosecute providers for performing services in New Hampshire that are legal. It is what we must do to ensure providers feel safe and able to practice reproductive health care in New Hampshire. We cannot continue to put the lives of women at risk by creating a hostile landscape for those who need access to reproductive care. And that is why we must overturn the committee recommendation on Senate Bill 575 and pass this bill today. Thank you, Mr. President.
Thank you, Senator Susi. Further discussion, Senator Altshuler, please.
Thank you, Mr. President. I rise in opposition to the committee recommendation. The landscape for reproductive health care, particularly abortion health care, is shifting under Americans' feet daily. The fragmented patchwork of laws with total bans in one state, partial bans in another, shows us how needed Senate Bill 575 is. It addresses crucial aspects of legal protection and cooperation in the realm of reproductive health care, ensuring the constitutional rights of individuals are respected and upheld in our state. In fact, this bill comprises several key provisions aimed at safeguarding the rights of individuals. It prohibits extraditing individuals for legally protected healthcare activity performed here in New Hampshire. Prohibits government officials or law enforcement agencies cooperating with out-of-state investigations into legally protected healthcare without court-ordered subpoenas or warrants. It prohibits adverse actions or discipline by the Board of Medicine, Board of Registered Nursing, or Pharmacy Board based on legally protected healthcare activity. And it prohibits against healthcare providers or other entities in New Hampshire from sharing confidential communications or information regarding reproductive healthcare services with out-of-state agencies or individuals without a valid court-issued warrant. This is about rights and privacy of our citizens. As a state, we deeply value the privacy of our residents to the point that we placed it in our Constitution in Article 2B, a right to privacy, that reads, an individual's right to live free from governmental intrusion in private or personal information is natural, essential, and inherent. SB 575 protects our residents' privacy from government intrusion in what is the most private of decisions. These are dangerous times for pregnant people, and we have seen the reproductive rights landscape change dramatically. For example, in Idaho, they have banned abortion at all stages of pregnancy and have become the first state to adopt an abortion trafficking ban. In Alabama, abortion health care is illegal, and their attorney general argues that he can file criminal charges against people who assist those getting abortion care outside that state. He also argues that people who organize travel for those leaving Alabama to receive abortion, for example, may be participating in a criminal conspiracy because abortion is illegal in their state, claiming that the conduct would be Alabama-based and is within Alabama's power to prohibit. An elective abortion performed in Alabama would be a criminal offense. Thus, a conspiracy formed in the state to have that same act performed outside the state is illegal. That's what the Attorney General in Alabama argues. And finally, Kate Cox of Texas, who bravely shared her experience of being subjected to reproductive servitude during a medical crisis. Her pregnancy was deteriorating rapidly due to a lethal, fatal fetal diagnosis of full trisomy 18. Continuing her already dangerous pregnancy posed a threat to Cox's full health and her future fertility. But her doctors refused to perform the needed abortion due to the state's near total ban on the procedure. She had to leave her home state in secret to get the abortion she needed to protect her life and her future fertility. We don't know. She could have come to New Hampshire. It's only $600 to travel from where she lives to Manchester Airport. And do we want the state of Texas reaching into New Hampshire to prosecute people who are getting health care that they need that's legal here? Last night at an event, a constituent shared with me their observation that these states imposing travel restrictions and prosecutions for assisting with travel and the bounties placed on pregnant people mirrored the Fugitive Slave Act. And I can't say he's wrong. Our residents need and deserve to have clearly outlined stability here in New Hampshire. They need to know we will protect them from the overreach of other states and uphold our laws, not the laws of Alabama or Texas or Idaho. The threat is real, and it could happen at any time, so we must act now. We must enact a shield law to protect patients and providers from overzealous and cruel prosecutors who want to reach into New Hampshire and prosecute for legal transgressions in other places. We need to ensure protection for patients and providers by preventing extradition and safeguarding confidentiality. Our residents need to know we're going to protect them. Patients need to know we're going to protect them. Providers need to know we're going to protect them. And we can do that today by overturning the committee recommendation and voting ought to pass on Senate Bill 575. Thank you, Mr. President.
Thank you, Senator Altschiller. Senator D'Alessandro, to speak or a question?
To speak.
Senator D'Alessandro is recognized to speak.
Thank you, Mr. President. I'll be very brief because it's a long day. The legislation's about health care. Health care. Taking care of people and taking care of their lives. We can't get OBGYNs to come to New Hampshire. They're fearful of what could happen. And yet we've been bragging all day about the quality of our laws and how we're protecting people in the 24-week situation. Come on. If we're going to brag about the good things we're doing, we ought to do good things to support them. This is a bill about health care. Gosh darn it, that Texas nonsense where that woman was forced to go out of state to have an abortion when she was told categorically that her child would not survive and that her life was threatened along with the child was going to pass away. I mean, let's be real. Let's try to do things that are good for people. It's about health care. It's about saving lives. It's about taking care of people who have needs. And if we force OBGYNs not to come to New Hampshire, what are we going to do with health care? What are we going to do? And we have to live with those decisions. Thank you, Mr. President.
Thank you, Senator D'Alessandro. Senator Birdsall, you're recognized to speak.
Thank you, Mr. President. Last night I was reading the hearing report on Senate Bill 575, and I noticed the good senator from District 14, quote, Senator Carson said state government can regulate intrastate commerce, but the federal government regulates interstate commerce. She believes there's a lot of nuanced federal law around this issue and that this bill isn't well written and it has many inconsistencies with federal law. Now, I will say, in relation to some of the hospital closings, I did get a phone call from Parkland before they closed their maternity ward. Their comments to me were, the birth rate is down, we can't do it. That's the reason Parkland closed. And with regards to a hostile environment for our doctors and our healthcare providers, I will say we have a 24-week, we do not have an abortion ban. The Northern New England Planned Parenthood website states abortion in New Hampshire are safe and legal. Our law solely restricts late-term abortions, and I'm sorry what happened in Texas, but that won't happen in New Hampshire. The Fetal Life Protection Act is very clear that an adult woman may have an abortion at her discretion up to 6 months. Thank you, Mr. President.
Thank you, Senator Birdsall. Senator Altshuler for a question.
Thank you, Mr. President. A question for my colleague from District 18.
Senator Soucy.
Thank you. Earlier today, we had a robust debate about how we had to change our statute around licenses that we don't really have for concealed carry because, and it was because of the laws of other states. So we had to kind of twist ourselves into a pretzel to accommodate the wants and needs of other states. We passed that. Should we not be concentrating on the wants and needs of our citizens and people who come here to seek health care and protect them when they get here?
Thank you, Senator, for the question. Yeah, they are two interesting juxtapositions. On the one hand, we're talking about a device and whether or not somebody could carry it somewhere else and use it in another state. This is talking about people who are trying to access health care and who, through no fault of their own, may fall victim to some very dire consequences. Whether they have filed suits yet or not, we have an obligation to protect New Hampshire citizens and those accessing health care while in the state of New Hampshire. Thank you.
Thank you, Senator Altshuler and Soucy. Senator Carson to speak.
Thank you, Mr. President. Again, I'd like to compliment my colleagues on a really good debate about this issue. But I ask you, what are we actually debating about? Has this actually happened? And I refer back to the testimony from Planned Parenthood, who was, in their testimony, said that the purpose of this bill is to shield other states from enforcing anti-abortion laws here in New Hampshire. But she noted that there has not been a hostile state take cross-border enforcement action for abortion. She goes on to say, but it doesn't mean it couldn't happen. Has anything happened? Has anybody been prosecuted? You brought up the woman from Texas. Was she prosecuted? I don't think so. First of all, you're talking about HIPAA, which is federal law. So how is someone going to find out? Unless you brag about it and you talk about it in the newspapers and decide to make yourself the case. No one is going to know. Let's talk about health care insurance. Usually we have national insurance, crosses state lines. That's interstate. That's in the purview of the federal government. Good luck trying to break that one. I just just don't see the need for this because we don't have a problem. We don't have a problem. You're trying to find a solution for a problem that doesn't exist. We talked today about politicizing issues. This is politicalization. You're trying to frighten people into thinking, oh my God, if I go to New Hampshire, they can tell the state that I'm from that I had an abortion here. It hasn't happened. It has not happened. We don't ask those questions. Also, I was very concerned about the licensure issue of our medical personnel. And the individual, who's a former colleague of ours, who works for a hospital here in this state, he was asked if doctors are afraid of being prosecuted. And he said, it's the patients who would be prosecuted. He was gone on to be asked if the doctors, again, would be subject to prosecution. And he said, I can't answer that question. So who is going to make the complaint against someone's license? Again, this doesn't happen. So why are we putting a law in just to say, oh, well, we're going to make people in other parts of the country, women in other parts of the country, if they decide to come to New Hampshire to have an abortion, that I'm not going to get prosecuted back in my home state, which has banned abortion. I don't know how you can do that, but this bill certainly doesn't do that. Thank you very much, Mr. President.
Thank you, Senator Carson. The motion is inexpedient to legislate. Senator Susi has requested a roll call, seconded by Senator Birdsall. The question is on adoption of the committee recommendation of inexpedient to legislate. If you're in favor of the ITL motion, you would say yes. If you want some other outcome, you would say no. Are you ready for the question? The clerk will please call the roll.
Senator Gendreau.
Yes.
Senator Lang.
Yes.
Senator Waters.
No.
Senator Prentiss.
No.
Senator Gray.
Yes.
Senator Ennis.
Yes.
Senator Ward.
Yes.
Senator Ricciardi.
Yes.
Senator Fenton.
No.
Senator Chanley.
No.
Senator Avard.
Yes.
Senator Rosenwald.
No.
Senator Carson.
Yes.
Senator Whitley.
No.
Senator Murphy.
Yes.
Senator Pearl.
Yes.
Senator Susi.
No.
Senator Birdsall.
Yes.
Senator D'Alessandro.
No.
Senator Perkins Kwoka is excused. Senator Abbas.
Yes.
Senator Gannon.
Yes.
Senator Altschiller.
No.
Senator Bradley.
Yes. The ayes have it, 14 to 9. Senate Bill 575 is found inexpedient to legislate. The Senate will please be attentive to the clerk.
Thank you, Mr. President. The Committee on Judiciary, to which was referred Senate Bill 577 FN, an act relative to imposing a waiting period between the purchase and delivery of a firearm. Having considered the same, the committee recommends that the bill is inexpedient to legislate by a vote of 3 to 2. Senator Abbas for the committee.
Senator Abbas.
Thank you, Mr. President. I move SB 577-FN inexpedient to legislate. This bill would establish a waiting period for the delivery of a firearm subject to certain exceptions. This bill allows for an individual to be denied the right to bear arms by the government for 3 days. However, in the same bill, it states that the government is going to determine when an individual feels safe and when they don't. The government determining when an individual is in fear without both parties present would set a dangerous precedent for even more guns to be taken away and confiscated from law-abiding citizens. For these reasons, a majority of the Senate Judiciary Committee asks for your support on the motion of inexpedient to legislate on Senate Bill 577-FN. Thank you, Mr. President, and I may speak additionally.
You may proceed.
So the arguments on this relied heavily on the issue of suicide. However, we're weighing the issue here, and we're also talking about constitutional rights and that are being infringed on during this waiting period. There was a lot of concerns about how that waiting period would have been calculated, whether it's from the time you go into the store, when you attempt to make the purchase. It wasn't a 72-hour window. there was some concerns with just the construction of the law, but it was also minimal evidence on the effectiveness of this, especially when you're talking about the amount of exceptions, which created a series of other issues on the enforceability and how those exceptions would be governed. When it comes to preventing suicide, I believe the most effective way is investing in mental health education and treatment in our state. And we've done a tremendous job doing that in the bipartisan budget that we passed, improving mental health treatment throughout the entire state. That treatment is the best way to prevent someone who has any mental health issue, including suicidal thoughts. Investments like these prevents those tragedies. When it comes to a 3-day waiting period, it doesn't even have any exception when someone already owns a firearm. We're talking about how much impact would this have. We do not see any evidence that this would actually impact the suicide rate. For those reasons, please join me and support the committee's recommendation of inexpedient to legislate. Thank you again, Mr. President.
Thank you, Senator Abbas. The motion is inexpedient to legislate. The bill is on further discussion. I would recognize, please, Senator Prentiss.
President, I rise in opposition to the committee's recommendation of inexpedient to legislate. And some of what I'm going to talk about, I've already talked about today. So at the risk of repeating myself, it is important to go to that place. So please open your ears and join, well, hopefully you'll join me in your vote. But to start off, I just want to talk about the waiting periods that, like the one found in 577. Earlier today, we heard my colleague from District 4 talk about means and how means actually matter, and the time, and then I take that into a place, which is also, you can find references to this in the T.H. Chan School of Public Health at Harvard, talks about the time period in between when somebody has a suicidal ideation and when they have access to a firearm, and actually the lethality of that. And if we can increase the time between when they're thinking about it and when they have access, we can increase their survivability. That's what I believe that we would want to do. So this talks about 3 days, giving a moment to pause. When we have somebody who is having an ideation, they have escalated emotions, impulsivity before going through an action which is irreversible. Sadly, and I talked about this earlier, I have been there, not just as a paramedic, but in my previous work as an associate deputy medical examiner. I have been in the homes. I have been, when I say at the side of the road, where somebody has actually taken their life in their vehicle, okay, on the side of the road. I have been there and seen what happens. I have talked to the families as part of my gathering of facts for reporting on what had happened. And I spoke about this earlier today. The families, the friends, many times they have said this was preventable. This isn't a surprise, but we couldn't do anything. We couldn't stop them. Earlier today we heard our senator from District 24, Senator Altshuler, talk about someone who came in, I believe it was to testify. You brought them in from maybe Exeter, whose child, from Portsmouth, whose child actually, when they couldn't have access to a firearm in their first pass, I believe it was in the home, went out, got money, went and bought it, and then committed suicide that very same day. So I think we can equally protect Second Amendment rights and equally protect people who are struggling with their own mental health. And I agree with the senator from District 22. I think this is the second or third time today that we've been closely aligned in agreement. This is a good thing. That mental health, the treatment for mental health services and advances that we've made in that area are going to impact this, but we're not completely there yet. And something that we do, not just in public safety, but in medicine, is that we have multi-pronged approaches to a problem, because not every medication, every therapy, every strategy will actually work for a particular situation. So I think we have to continue down that, but these two things can coexist without impacting someone's Second Amendment rights. if indeed, they go through the waiting period, they can still get, they have access to that firearm once that is over. And hopefully, by putting that time in between this thought and the lethal act that they want to take, we can shrink this. Actually, what we want to do is increase survivability. So, that being said, this is a public health crisis, one which has far-reaching impact just beyond one person. There are multiple sources of data. In my professional life, I use the CDC's website for whiskers, which you can actually tinker and do specified queries for your own states and your own reasons. But for every suicide death, there were about 3 hospitalizations for self-harm, 8 emergency department visits related to suicide, 38 reported suicide attempts in the past year, 265 people who seriously considered suicide in the past year. The sources to this, Whiskers, SAMHSA, and the National Inpatient Sample from what they call HICCUP. In the Granite State, suicide is the second leading cause of death of young adults between the ages of 15 and 24. The New Hampshire Suicide Prevention Council's 2019 report stated that the vast majority of violent deaths in New Hampshire are suicide. For every homicide in New Hampshire, there are approximately 14 suicides. This ratio is a sharp contrast to the national statistics that show approximately 2 suicides for every homicide. For every suicide death in New Hampshire and nationally, there are approximately 3 deaths classified as unintentional, according to Whiskers. Overall, suicide constitutes a larger proportion of all traumatic deaths in New Hampshire than in the U.S. as a whole. So what does this public health crisis have to do with a waiting period for a firearm? When compared to other means of attempting suicide, guns are uniquely lethal. More than 90% of suicide attempts with a firearm result in death, a staggering statistic when compared to other suicide means, which come in closer to 5%. My colleague from District 4 earlier talked about overdose, poisoning, and suffocation, and one of them, in relation to suffocation, is going to be carbon monoxide poisoning. A slower death where you're more likely to be found and actually rescued than not. Unfortunately, that isn't always the outcome, but what we're speaking to here in terms of this part of the public health crisis is this is immediate and fatal, irreversible. Further evidence-based suicide prevention practices involve making a suicide attempt method less available or more difficult to access. Again, a firearm immediately, which we've already talked about, and a waiting period would assist with this. Our residents are struggling. They are suffering from this tragic public health crisis, with some populations, like our veterans, being at even higher risk of use of firearms, with the Department of Veterans Affairs reporting 71% of veteran suicides are related to a firearm, sadly. So we've had multiple discussions about this today, and I brought up earlier, what are we waiting for? Say it one more time. We need to act. We need to take steps to support our residents who are in crisis. And again, the mental health treatment component of this and these investments we've made are, they're extraordinary, and we need to keep going down that path, but this is a multi-pronged approach. So we can do just this with Senate Bill 577. We can give people that moment to pause. We can give them a chance to reconsider. We can give them an opportunity to breathe before it's too late. Thank you, Mr. President.
Thank you, Senator Prentiss. Senator Altshuler, you are recognized to speak.
Thank you, Mr. President. I rise in opposition to the committee recommendation. It is our duty as legislators to strike a balance between the protection of individual freedoms and the safety of our communities. It is a duty we should take solemnly and seriously in this role that we have, and it is one that I know and we all know, given our discussions here today, is fraught with challenges. However, I also know that Senate Bill 577 achieves that balance with a thoughtful and measured approach. The 3-day waiting period is a proactive step to prevent impulsive acts of violence and promote responsible gun ownership. It provides a crucial window of time for thorough background checks, ensuring that firearms do not end up in the wrong hands. A waiting period of 3 days, allowing individuals to reconsider their decision to purchase a firearm in moments of heightened emotion or crisis. And I know you've heard from my colleague here today horrifying statistics and facts regarding suicide rates in our state. And when a gun is involved, and I know that even given those realities, many of you still see this language as too far of an infringement on a right that you hold dear. But I implore you to see this bill for what it is, a carefully crafted balance of rights, one that sees the need for a balanced approach for our public safety and our constitutional rights. Even beyond this balance, this bill also holds various exceptions to its requirements, further lessening the burden on our people seeking to purchase guns in our state. I will note, throughout this bill, there are carefully crafted exceptions that respect the rights of law-abiding citizens and acknowledge the need for situational exceptions. And these were put in because previous objections to this bill were expressed by a colleague. And so to meet those needs, we have included them in the bill. Let's be clear about what those exceptions are. For one, this waiting period does not apply to firearm trade-ins. It does not apply to individuals who have completed a 16-hour hunter education course, or active duty law enforcement officers, or active duty correctional officers, or active duty members of the armed forces. At the request of previous debates on this bill, these were included to be presented. Furthermore, this will not apply to individuals who have obtained a valid restraining order or expressed a reasonable fear for their personal safety. These exceptions are appropriate and effective in respecting the rights of the individual with the need to address our public safety realities. I need to remind this body that when this bill had come up before, the objection was, what about people who feel fear for their personal safety? Now it's in. So I take exception to objections that, how do we do this? People who fear for their personal safety. You got what you asked for. Senate Bill 577 is a testament to our balanced approach here in the New Hampshire Senate of holding both our commitment to public safety while also not infringing on the rights of our citizens. It addresses concerns raised by our citizens, mental health communities, law enforcement agencies, providing comprehensive framework to ensure that our law enforcement, first responders, medical professionals, and community members are not at the barrel end of a firearm in the hands of someone who is unfit to possess it, while ensuring individuals can still exercise their Second Amendment rights. I understand. Some of my colleagues don't agree with this assessment. They see this as an overreaching infringement on their Second Amendment rights, arguing that law-abiding citizens have the right to access firearms for self-defense or whatever reason they want without delay. However, I submit to you that in accordance with Article 3 of the New Hampshire Constitution, a short 3-day waiting period is an important suicide prevention measure that provides a cooling off time for impulsive, violent acts and gives an increased amount of time for law enforcement to conduct thorough background checks. This is a reasonable and balanced approach to the reality of the world and the time we live in now. When men enter into a state of society, they surrender up some of their natural rights to that society in order to ensure the protection of others. And without such equivalent, the surrender is void. Our Constitution recognizes there's a balance. So, I ask my colleagues to join me in overturning the committee recommendation and supporting this piece of legislation, because with the passage of this bill, we send a clear message that we prioritize the well-being of our citizens while upholding the values of individual freedom. Let's stand united in pursuit of a safer New Hampshire. This is another opportunity to do a good thing. And I'd like to quote Senator D. It's really nice when we do the right thing. So let's make him proud, vote to overturn this and pass this bill. Thank you, Mr. President.
Thank you, Senator Altshuler. Senator Carson to speak.
Thank you, Mr. President. I'd like to ask the members of this body, what constitutional right are you willing to wait for? Can you identify one that you think, well, freedom of speech, I'll wait 2 or 3 days before I say something? We don't. We don't wait. And I would ask the body, we started out the day talking about CACR 24, giving women the constitutional right to an abortion in this state. Who here would like to see a waiting period? 3 days, 5 days, for you to stop and consider what you're going to do. I have a distinct impression that that would not happen. But here we are talking about a different constitutional amendment, yet again with the caveat that it's going to prevent suicides. But basically what you're going to be doing is you're going to be disenfranchising thousands of Granite Staters who've done nothing wrong. Who've done nothing wrong except go to buy a gun. That's all they've done. And it makes the assumption, well, you really don't know what you're doing. We want you to take a few days and we want you to think about what you're doing. Would we pose those same questions to a woman seeking an abortion? No, we wouldn't. But yet here we go. We say yes. In the bill, it talks about reasonable fear. Well, what's reasonable fear? And who gets to determine that? Well, do you want the government to determine when an individual feels safe and when they don't? I always thought it's up to the individual whether or not they feel safe. And quite frankly, Mr. President, if we're going to go down that road, is 3 days enough? Why not a week? Why not a month? If you're going to abridge someone's constitutional rights, well, you know, let's do it up and let's do it up right. Let's wait a week. But we're not going to do that, Mr. President. We value an individual's constitutional right. You might not like the fact that someone wants a gun. That's okay. But our country recognizes that we have a right, a constitutional right. And yes, it can be abridged, but very rarely should it ever be abridged. So basically, we're saying with this bill, yeah, okay, we're going to give you this, you have this right, but we don't trust you. We don't know if you're going to do something really bad with this piece of legislation. You could hurt somebody else. You could hurt yourself. So we're going to abridge your rights for a couple of days while you determine what you're going to use this for. It's not right, Mr. President. Granite Staters, law-abiding Granite Staters, should not be subjected to something like this. I think I'm going to end, Mr. President, with something that I said on one of the other gun bills. According to U.S. News, we are the safest state in the nation because we protect the Second Amendment and we don't defund our police. We're standing here today to protect our citizens' right to own a firearm, and we're not going to make them wait 3 days in order to get it. Thank you very much, Mr. President.
Thank you, Senator Carson. The motion is inexpedient to legislate. Senator Lang for a question.
14.
Senator Carson.
Thank you for taking my question. So my question is, we just heard earlier today from the governor talking about families in crisis and people in crisis and using pound 211 in order to get services here in New Hampshire. Can you tell me of any recent improvements we've done? We've talked about suicide, which is truly a mental health issue. And what investments have we made into mental health?
Well, thank you. As I listed earlier, we've listed an incredible amount of resources in mental health. But I think one of the most important ones is the mobile crisis team that has been put into place. A few years ago, a bunch of us went down to New Jersey, and we were looking at their child protection system. And one of the things that they did was they had a mobile crisis team that goes to where you are. This is why, 211, you can get a mobile crisis team if you are suicidal or if you're living with someone who is suicidal. 211, you'll get the mobile crisis team to where you are, and you can help, and they can help diffuse the situation. So I think that is a huge plus for us, and it is something that we did on a bipartisan basis, and it's working very well for New Hampshire.
Thank you for answering the question.
Thank you.
Thank you, Senator Lang and Senator Carson. Senator Altshuler?
Thank you, Mr. President. I want to apologize to my colleague from District 5. I need to correct. You were making reference to my constituent who died by suicide after being able to access a firearm, and that was in Exeter. But this bill heard from a mom in Portsmouth. Her name is Donna Morin, and she came here and she sat in that committee room and she picked away at a very tender scab. Her son, just over the age of 18, had a very bad breakup one afternoon. He was old enough to buy a firearm. He had cash. He went and purchased the firearm. He came back to his house, texted his mom, "I'm sorry," and shot himself in the head in their home. She came here and bared her soul emotionally because she's not the only one, and she knows that. She knows that because she's part of a community of families of people who have died by suicide with a firearm, because 80% of the suicides here in New Hampshire are with a firearm. And now she belongs to this club she never wanted to be part of. And she is desperate that nobody else joins that club. She came here and poured her heart out, told her story about how her son, in a very, very heightened moment, was able to purchase a firearm, and he used it within 30 minutes of purchase. Had there been a waiting period, Donna Morin would still have her son here. She wouldn't be going to a gravesite. She wouldn't be coming here holding it together to try to make a point, to try to turn your hearts, to try to wake this legislature up that we have to do something. We have to take action on gun violence prevention. We have punted twice today. You have another chance right now. You have a chance to go home to your constituents and look them in the eye and say, "I know, I understand I don't want this to happen to anyone else either. It's 3 days. 3 days. Now, if someone would like to bring in a floor amendment to make it 7 or 10, by all means do. But we heard testimony from NAMI, New Hampshire, that 3 days is the magic number to interrupt a crisis moment. Was Donna Moran's son mentally ill? Nope. No, he wasn't. He was fine. He had a bad breakup and got despondent and found a permanent solution to a temporary problem. You can do something good. Take the opportunity.
Thank you, Senator Altschiller. The motion is inexpedient to legislate. Seeing no further discussion, I believe Senator Altschiller is called for a roll call, seconded by Senator Susi. The question is on adoption of the committee recommendation of inexpedient to legislate. Are you ready for the question? The clerk will please call the roll.
Senator Gendreau.
Yes.
Senator Lang.
Yes.
Senator Waters.
No.
Senator Prentiss.
No.
Senator Gray.
Yes.
Senator Innes.
Yes.
Senator Ward.
Yes.
Senator Ricciardi.
Yes.
Senator Fenton.
No.
Senator Chandler.
No.
Senator Avard.
Yes.
Senator Rosenwald.
No.
Senator Carson.
Yes.
Senator Whitley.
No.
Senator Murphy.
Yes.
Senator Pearl.
Yes.
Senator Susi.
No.
Senator Birdsall.
Yes.
Senator D'Alessandro.
No.
Senator Perkins Kwoka is excused. Senator Abbas.
Yes.
Senator Gannon.
Yes.
Senator Altschiller.
No.
And Senator Bradley.
Yes. The ayes have it, 14-9. Senate Bill 577 has been found inexpedient to legislate. The Senate will please be attentive to the clerk.
Thank you, Mr. President. The Committee on Capital Budget, to which was referred Senate Bill 476 FN, an act making and a capital appropriation to the Department of Corrections towards the replacement of New Hampshire State Prison for Men. Having considered the same, the committee recommends that the bill is ought to pass by a vote of 4-1. Senator Gray for the committee.
Senator Gray.
Thank you, Mr. President. I move Senate Bill 476 ought to pass. This bill represents a critical step forward in addressing infrastructure needs in our correction system and ensuring safety and security of both the inmates and the staff of the New Hampshire State Prison for Men. Senate Bill 476 appropriates $40 million for the architectural, engineering, programming, and design and construction documents for the new correctional facility. This investment will facilitate the development and modernization and more effective prison infrastructure that meets contemporary standards for correctional facilities. Additionally, this bill authorizes the issuance of bonds to provide the necessary financing for this project without burdening the state's finances beyond its manageable effort. The Capital Budget Committee asks for your support on a motion of ought to pass on Senate Bill 476. Thank you, Mr. President.
Thank you, Senator Gray. The bill is on second reading. Is there any discussion? Senator D'Alessandro?
Just wanted to mention to my colleagues a little history behind the prison and the mistakes that we have made over the years that have been very costly. Now we're talking about an expenditure of $40 million more dollars. We put $10 million in the budget for the design of the facility. I first went to the prison in 1958 and met Warden Hancock. There were 325 prisoners at the time. He lived on campus and he knew every person who was in that facility. In 1973, we had a riot at the prison, an extensive riot. That riot burnt down part of the prison, and Lamens was there, And Lammons was one of the real super criminals in New Hampshire's history. He was a murderer. We're still under the Lammons decree, by the way. This is started in 1973, but exists today with regard to the prison. So for 50 years, we've been thinking about doing something. Let me tell you the steps we've taken in between. We built the Northern Correctional, before we built the Northern Correctional Facility, we went to the Laconia State School, took that over and made it a minimum security prison. We took prisoners out of Concord and sent them to Laconia. We then made a deal with Laconia for the expansion of the minimum security prison by giving them a ballpark and creating a series of sidewalks around the facility. We then built the Northern Correctional Facility in Berlin with the caveat that if we ever needed any more prison space, we could expand this facility, the Northern Correctional Facility. I don't see anything on the plans to do that. In the interim, in 1973, we had a massive study done about what should be done with regard to the prison system in New Hampshire. Halfway houses, the women's prison, and the men's prison. That study was done. You can go look at it. It's in the library. I don't think there's a lot of moss on it, but a lot of people haven't taken it out in the last 50 years, I'll tell you that. So we had that done, and now we're going to spend $40 million for the New Hampshire State Prison. And we know we need it. We know we need it. But in the interim, we built a women's prison. We used to rent the Hillsborough County Jail in Goffstown. How many of you visited that place, the women's prison? Oh, the worst mess in the world. Talk about prison. It was the worst. It was the worst. As a matter of fact, when they closed it down, they tore it down the next year. Tore it down. So here we are, 50 years later, and we're going to spend $40 million on a new facility that it took us 50 years to make this decision. Hope we don't make these kinds of mistakes again. I hope we don't. And think of what we've done in the budget year after year after year with regard to the Concord prison, the kind of dollars we have expended there. Thank you, Mr. President.
Thank you, Senator D'Alessandro. The bill is on second reading. Is there any further discussion? The question is on adoption of the committee recommendation of ought to pass on Senate Bill 476. Senator Avard has requested a roll call, seconded by Senator Lang. The members will please be attentive to the clerk.
Senator Gendreau.
Yes.
Senator Lang.
Yes.
Senator Waters.
Yes.
Senator Prentiss.
Yes.
Senator Gray.
Yes.
Senator Innes.
Yes.
Senator Ward.
Yes.
Senator Ricciardi.
Yes.
Senator Fenton.
Yes.
Senator Chanley.
Yes.
Senator Avard.
Yes.
Senator Rosenwald.
Yes.
Senator Carson.
Yes.
Senator Whitley.
Yes.
Senator Murphy.
Yes.
Senator Pearl.
Yes.
Senator Susie.
Yes.
Senator Birdsell.
Yes.
Senator D'Alessandro.
Yes.
Senator Perkins Kwoka is excused. Senator Abbas.
Yes.
Senator Gannon.
Yes.
Senator Altschiller.
Yes.
And Senator Bradley.
Yes.
23.
The ayes have it, 23-0. Senate Bill 476 is ordered to the Committee on Finance. The Senate will please be attentive to the clerk.
Thank you, Mr. President. The Committee on Commerce, to which was referred Senate Bill 330FN, an act relative to allowing the ability to work from home to count towards unemployment benefits eligibility. Having considered the same, the committee recommends that the bill is ought to pass by a vote of 5-0. Senator Susie for the committee.
Senator Susie.
Thank you, Mr. President. I move Senate Bill 330FN ought to pass. This bill would modernize the unemployment compensation statute by permitting the ability to work from home to count towards unemployment benefits eligibility. In the post-pandemic environment, the labor market has changed significantly. In New Hampshire, for example, 34% of employers plan to continue to offer some level of remote work. This bill would allow an individual to limit their search to remote work if there were a reasonable expectation of substantial employment. The Department of Employment Security would have rulemaking authority to determine the sectors that do not provide a reasonable expectation. This bill recognizes the needs of a modern economy and modern workforce. I especially want to thank my colleague, Senator Perkins Kwoka, for her work, both with the department and with stakeholders who came together on this very important legislation and reached consensus. The Commerce Committee asks for your support on the motion of ought to pass on Senate Bill 330 FN. Thank you, Mr. President.
Thank you, Senator Susi. The question is on adoption of the committee recommendation of ought to pass on Senate Bill 330. Are you ready for the question? All in favor, please say aye. Aye. Any opposed? The ayes have it. The motion of ought to pass is adopted.
Could I request a 2-minute recess, please?
2-minute recess. The Senate will come back into session, please. I neglected to say that Senate Bill 330 is ordered to third reading. So Senate Bill 330 is ordered to third reading. So before we turn to the Education Committee, we do have dinner coming. It should be ready downstairs by about 4:30. I believe we only have maybe 2 debates, and I believe they'll both be short. So if we really mind our P's and Q's, we'll be able to finish the calendar, and then we can have a nice dinner, and Senator Pearl can go plow, and the rest of us can eat dinner and still be home before it starts to snow. Okay? All right. The Senate will please be attentive to the clerk.
Thank you, Mr. President. The Committee on Education, to which was referred Senate Bill 339, an act relative to repealing graduation requirement regarding free application for federal student aid applications. Having considered the same, the committee recommends that the bill is ought to pass with an amendment by a vote of 3-2. Senator Gendrew for the committee.
Senator Gendrew.
Thank you, Mr. President. I move Senate Bill 339 ought to pass as amended. Senate Bill 339 would eliminate the requirement for high school students to complete the free application for federal student aid, otherwise known as FAFSA, as a condition of graduation. While the FAFSA provided valuable information to students regarding opportunity and aid at their disposal, the committee felt that repeal of the requirement was necessary given it was a non-academic mandate. Further, members of the committee found the application to be invasive and burdensome to the extent that it may pose as a barrier to graduation for some students. I respectfully ask that you please join the Senate Education Committee in supporting the motion of ought to pass as amended for Senate Bill 339. Thank you, Mr. President.
Thank you, Senator Gendrew. The bill is on second reading. The first order of business is the committee amendment. Is there any discussion? Seeing none, the question is on adoption of the committee amendment. Are you ready for the question? All in favor, please say aye. Aye. Any opposed? No. The ayes have it. The committee amendment is adopted. The bill is on second reading. Is there any further discussion or amendment? Senator Prentiss.
Thank you very much, Mr. President. So I rise in opposition to the ought to pass motion. I have handy here the hearing report from 2021, where as a body, when we voted on this bill in 2021, and we passed it 24-0, putting this requirement in place. So, and many of you were here then and are here now. So I just wanted to bring that up. But I wanted to clarify a few points on why I am in opposition to rolling this back. So some of the things that my friend from District 1 mentioned in the introduction to the bill talks about, being an obstruction or being problematic as a graduation requirement, talking about the data being invasive, talking about, she didn't bring this up, but it came up during the hearing, a correlation between completing this and actually taking on more student debt. So a few things that I want to say about this, but I want to start with the reason that we passed this, I believe, looking at the hearing report in 2021, is because we wanted to make sure that all students and their families understood, especially our lower income, our moderate to lower income folks, on what might be available to them in terms of grants and aid. And it maybe even student loans, but that's up to them. So this was putting that on the table, but knowing, as we discussed in this hearing and have discussed in others, that post-secondary, when we talk about post-secondary education, is not a pathway for everyone. This was just a way to get on the table what exactly is available for families to consider it, but did not tie them to actually doing it. So that was a big reason that we put this in place. Number one, there is an opt-out provision already in. So if families and students don't want to complete this, because then they don't have to do it, they can opt out and it won't become a barrier to their graduation requirement. Number two, data. You know what? I remember filling this out for my Phoebe. It was pages and pages and pages and hours, okay? Guess what? It's only 35 questions now. Okay, so they've taken that action not only with the federal government and the Lamar-Alexander Act, but that's what we have now. And according to this hearing report from 2021, that is been in the process of going into place between 2023 and 2024. So we really don't know if this is an issue. Okay, we just know that there's a concern about that. And I just again wanted to bring up that I have not been able to, and if somebody can point me to it, a correlation between completing this and actually taking on debt and more debt than you should take on, I'm happy to have that discussion. But we passed this for a reason as a body. Students and families should know, especially our lower and moderate income families, what's available to them. They don't have to take it. This won't be a barrier to their graduation if they opt out. And we're at I wish I was at 35 questions when I was filling this form out. So thank you very much.
Thank you. Senator Prentiss. Senator D'Alessandro to speak.
Thank you, Mr. President. I rise against the bill. I've been in the education business most of my life. The FAFSA is an easy form, but it does one thing that's essential. It allows financial packaging to take place, and we package kids when they choose post-secondary education. If they don't see the package, they leave a lot of money on the table because the basis of the grant is the initial Pell Grant, which used to be the state student incentive grant. Now, the student incentive grant was again for kids without with financial need, without money. It's now the Pell Grant, named after Claiborne Pell, who was a senator from the state of Rhode Island. The Pell Grant now is up to about $7,000. It's a great base to build upon. If you don't fill out the FAFSA, you can't find out about the Pell Grant. Doesn't mean you have to go to school, but it does give you a base to drive off of. And indeed, the rest of the scholarship assistance that you could get is in the package. The package includes merit aid, it includes SSIG, a secondary supplement education grant. All of these things would not be available to the student if you didn't fill out the FAFSA. Now, the old financial aid form was a pain in the neck. I agree. It was difficult. And many people didn't want to do it because sometimes you had to produce your 1040. And that kills you at the end because everybody's trying to duck money rather than tell what they were really making. I understand that. But I've done this for most of my life. And I'm telling you, this is the best way for a youngster to find a path to post-secondary education. They could go to any community college, university, technical school, whatever. But it provides an opportunity to find out what's available. What's available. And by the way, Pell Grants are FF for free. You don't have to pay them back. They're for free. And sometimes you get stuck with the GSIL, the Guaranteed Student Loan. That's a bit problematic, but at least you're going to find out about that by filling out the form. It's something that's worth doing, and it has a place in your life. Thank you, Mr. President.
Thank you, Senator D'Alessandro. Senator Ward.
Thank you, Mr. President. We did discuss this at great length, and I was here in 21 when we voted and we had a legislator who was adamant about FAFSA. That's the first time I learned about it. It seems to me now, though, that I have heard from parents they really resented filling out that form. Some of them forgot to do it, and then, you know, you sort of get stuck there just before graduation. And why have that, filling out that form, having to do with whether or not you can graduate from high school? To me, that is unreasonable. My experience is that there are a lot of counselors at the high schools. They'll tell you about the different grants available. They can talk you through it and help you with it. Yes, you can opt out presently, but a lot of people forget to opt out. So my big thing about it is that you have to do it in order to graduate, and I don't think that's fair. I think that infringes on your liberty and your choices. Thank you.
Senator Fenton for a question.
Of my colleague from District 5. And I think my other colleague just mentioned this, but I just want to clarify. Is there an opt-out in this already?
Thank you for the question. Yes.
Thank you.
And if I may say, I think it's our duty to make sure that families know about this and we can support school systems in doing that. Thank you.
Senator Prentiss, did you have a question?
I have a question for the senator from District 20. May I? I know. Senator, I promise I'm going to go really fast here. Oh, no, I'm kidding. No, I'm going to ask Lou. No, I know we all, want to get home. No, hang on. No, I promised him that I would, not slow roll it tonight. So, Senator D, it's one and potentially a follow-up. Do we have civics education programs? Do we have civics education requirements in our school systems?
Yes, we have a civics education requirement.
Follow-up? Do you have to complete that civics? Now, I know there can be a course, but there's also a requirement, as you just stated. Do you have to complete that course or that online program in order to graduate?
Yes, you do.
Thank you.
You're welcome.
Senator Ricciardi to speak.
Thank you, Mr. President. I just wanted to say that I was on education when we had passed the bill originally, and I was in support of it, but the reason I've changed my position is simply I heard from the school superintendents in my district, and they asked to not have this. And I heard from the parents. So I'm responding to my superintendents and my constituents. Thank you.
Ricciardi. Senator Murphy?
Yes. For my friend from District 5, please.
Senator Murphy, we meet again.
Yes. Good to stand up for a change. My question is, if you're a high school senior and you have made the decision that you're going to be an electrician or a plumber or an HVAC technician, and you've already set up a paid internship, a paid apprenticeship, why should you be forced to fill out a FAFSA, or your parents be forced to fill out a FAFSA to get your diploma?
Thank you for the question. And as I stated earlier, not all children are going to choose a post-secondary pathway. So I completely support the trades, but you don't have to fill this form out. You can opt out of doing it. We're not forcing them to. And I think the lesson here is in actually educating the communities that they don't have to do that. So I'm not trying to force them to. It's there as an option for them. They can opt out. Thank you for the question.
Thank you.
Senator Innes to speak. Oh, I'm liking that. All right, seeing no further discussion. Are you ready for the question? All in favor of the motion of ought to pass with amendment, please say aye. Aye. Any opposed? No. The ayes have it. The motion of ought to pass prevails, and Senate Bill 339 is ordered to third reading. We'll now turn to the Committee on Election Law. Senator Gray. The Senate President will abide by the rules and say that we're going to be attentive to our great clerk.
The Committee on Election Law and Municipal Affairs, to which was referred Senate Bill 527, an act relative to student housing. Having considered the same, the committee recommends that the bill is ought to pass with an amendment by vote of 4-0. Senator Gray for the committee.
Senator Gray.
Thank you, Mr. President. And as you will note, I didn't say anything until you corrected that.
Will abide by the rules.
I move Senate Bill 527 ought to pass with amendment. This bill, as amended, adds a new paragraph to the Planning and Zoning Statute, RSA 671:1, which is the Declaration and Purpose section, in order to address student housing. Due to the shortage of workforce housing across the state, many communities have made investments to add available rental units. Municipalities that host colleges or universities are seeing these units rented by students, leaving none available as intended for the workforce. Senate Bill 527 will establish a committee with the purpose of developing a collaboration between the college and municipality that will strike a balance between the student and the workforce housing. In order to do that, the committee will research and determine a clear definition of student housing, create a consistent policy on which constitutes housing for the students, will benefit from the municipalities across the state when they are considering zoning and planning. The Election Law and Municipal Affairs Committee asks for your support and motion of ought to pass with amendment on Senate Bill 527. Thank you, Mr. President.
Thank you, Senator Gray. The bill is on second reading. The first order of business is the committee amendment. Is there any discussion on the committee amendment? Seeing none, all in favor, please say aye. Aye. Any opposed? The ayes have it, and the committee amendment is adopted. The bill is on second reading. Senator Prentiss, you are recognized to introduce Amendment 720.
Thank you, Mr. President. So introducing Floor Amendment 2024-020S. First, I want to thank the members of Election Law, Municipal Affairs, and my colleague, Senator Gray here from District 6, in their thoughtful deliberation of this and even the way that they amended it. But I don't think you can fault me for just trying to put just a slight bit more meat on the bones. First of all, I want to fall on my sword and say when I first introduced this, it is only supposed to be an addition to the declaration of that particular RSA. There is a second section of this that had an enforcement mechanism in it, and that was my error, and I amended that out. Further, so that I was wrong, learned my lesson. I just want to own that up front because there's been a lot of confusion. Secondly, in this amendment, it does recognize, so what the committee brought forward preserves, the very first line about the state receiving many economic and social benefits from its post-secondary institutions. I would just like to be able to add the 2 more sentences back in, and I struck the very last sentence, which seemed to give the most heartache to the town and city managers that I talked to about this. And I want to also just thank Senator Gray in terms of his introduction and talking about we've made significant investments in workforce housing. We heard the governor talk today about the growth of our workforce and the housing that stock that we are building out. But we do have a situation in certain communities where there is the inability to protect that for its initial purpose. So I just wanted to try to put more meat on the bones, but I do appreciate the work the committee has done. So I'd ask folks to join me in passing this floor amendment, and thank you for the opportunity.
Thank you, Senator Prentiss. Senator Gray.
Thank you, Mr. President. Certainly when in committee that I suggested striking certain language out of the original bill, I did that because there is also other portions of that declaration and purpose statement that affect this. In fact, Section E talks about all citizens benefit from the balanced supply of housing, which is affordable, and then does go on to talk about lower income and families. Certainly that covered part of what the senator had put in there to begin with. And right now, I think that if that section of that needs to be changed, that should be a recommendation of the committee and not done at this time. Thank you, Mr. President.
Thank you, Senator Gray. The question is on adoption of Floor Amendment 720. Are you ready for the question? All in favor of the floor amendment, please say aye. Aye. Any opposed? No. I believe the ayes have it. The ayes have it. The floor amendment is adopted. The bill is on second reading and open for further discussion and/or amendment. The question is on adoption of ought to pass as amended on Senate Bill 527. Are you ready for the question? All in favor, please say aye. Aye. Any opposed? The ayes have it. The motion is adopted. Senate Bill 527 is ordered to third reading. The Senate will please be attentive to the clerk.
Thank you, Mr. President. The Committee on Election Law and Municipal Affairs, to which was referred Senate Bill 531, an act relative to background checks of municipal health officers. Having considered the same, the committee recommends that the bill is ought to pass by a vote of 3-0. Senator Gray for the committee.
Senator Gray.
Thank you, Mr. President. I move Senate Bill 531 ought to pass. This bill provides municipalities to be responsible for reviewing and maintaining the criminal background checks of nominated health officers. Currently, the state requires the Department of Health and Human Services to receive the background checks and determine if the candidate qualifies. This necessitates the Division of Health and Human Services maintain and store these sensitive information as well. The department requests that the legislation in order to restore local authority to the municipalities over who they hire. Local health officers are town employees and serve according to the local human resources standards and should be subject to local hiring practices. Additionally, keeping the background checks with the municipality reduces the privacy concerns and the administrative burden that exists when they are maintained by the Department of Health and Human Services. The Election Law and Municipal Affairs Committee asks for your support on a motion of ought to pass on Senate Bill 531. Thank you, Mr. President.
Thank you, Senator Gray. The bill is on second reading. Is there any further discussion? Seeing none, the question is on adoption of the committee recommendation of ought to pass on Senate Bill 531. Are you ready for the question? All in favor, please say aye. Aye. Any opposed? The ayes have it. The motion of ought to pass is adopted. Senate Bill 531 is ordered to third reading. Okay, let's move with alacrity to the Committee on Energy. The Senate will be attentive to the clerk.
Thank you, Mr. President. The Committee on Energy and Natural Resources, to which was referred Senate Bill 303 FN, an act relative to the use of renewable energy funds by the Department of Energy. Having considered the same, the committee recommends that the bill is ought to pass with an amendment by a vote of 4-0. Senator Avard for the committee.
Senator Avard.
Thank you, Mr. President. Hey, we're in energy. It's getting close. I move SB 303 ought to pass with amendment. This bill was requested by the Department of Energy to make changes in how Renewable Energy Fund is administered to be better aligned with what is currently happening in the energy sector. The Renewable Energy Fund is funded through alternative compliance payments made by electric distribution utilities and competitive suppliers who cannot acquire enough renewable energy certificates to comply with state law. The department then uses these funds to provide grants and rebates, renewable energy projects that generate more renewable energy certificates in the future. Needless to say, the energy sector is moving by leaps and bounds, and the state program needs to be able to keep up with the market changes to ensure that the limited state funds are making the difference in these projects happening, rather than just subsidizing projects that would have happened anyway. Perhaps the most importantly, that this bill directs the department to establish programs specifically designed for political subdivisions, which help our cities, our towns, and our counties to reduce their energy costs, reducing the pressure on property tax rates. The committee amendment addresses a few technical issues brought up during the hearing, and I urge you to support the committee recommendation of ought to pass, and I thank you, Mr. President.
Thank you, Senator Avard. The bill is now on second reading. The first order of business is the committee amendment. Is there any further discussion of the committee amendment? Seeing none, are you ready for the question? All in favor, please say aye. Aye. Any opposed? The ayes have it, and the committee amendment is adopted. The bill is on second reading. Is there any further discussion or amendment? Seeing none, the question is on adoption of ought to pass as amended. Are you ready for the question? All in favor, please say aye. Aye. Any opposed? The ayes have it. Senate Bill 303 is ordered to third reading. The Senate will be attentive to the clerk.
Thank you, Mr. President. The Committee on Energy and Natural Resources, to which was referred Senate Bill 320 FN, an act requiring the Public Utilities Commission to establish gas and electric performance incentive mechanism. Having considered the same, the committee recommends that the bill be re-referred to interim study by a vote of 4-0. Senator Waters for the committee.
Senator Waters.
Thank you, Mr. President. I move Senate Bill 320 FN for interim study. recognizing the significance of Senate Bill 320 and aligning the utility business model with state goals. Concerns have been voiced by the Department of Energy and the PUC. The complexity and potential risks associated with a comprehensive shift in utility regulation necessitates a thorough assessment before implementation. Supporters do emphasize the bill's role in initiating conversations about performance-based rate making. However, the Department of Energy expresses opposition, citing the bill's mandate and the need for flexibility in evaluating proposals based on merit. Given these complexities, the Energy and Natural Resources Committee believes this topic needs further review and study, so the Energy and Natural Resources Committee asks your support to move SB 320 for interim study. Thank you, Mr. President.
Thank you, Senator Waters. The motion is refer for interim study. Is there any discussion? The question is on adoption of the committee recommendation of refer for interim study. Are you ready for the question? All in favor, please say aye. Aye. Any opposed? The ayes have it. The motion of refer for interim study is adopted. The Senate will please be attentive to the clerk.
Thank you, Mr. President. The Committee on Energy and Natural Resources, to which was referred Senate Bill 329FN, an act relative to background checks of certain persons associated with solid waste management. Having considered the same, the committee recommends that the bill is ought to pass by a vote of 4-0. Senator Pearl for the committee.
Senator Pearl.
Thank you, Mr. President. I move Senate Bill 329 ought to pass. This bill addresses technical issues and provides necessary cleanups from the implementation of Senate Bill 211 last year. This bill is a collaborative effort with the Department of Environmental Services that enables the department to request the Attorney General to perform a background check on the people associated with solid waste facility permit applicants. This bill is important for aligning language with the original intent of Senate Bill 211 to allow for a thorough review of people associated with the solid waste facility. The Energy and Natural Resources Committee asks for your support on the motion about to pass for Senate Bill 329. Thank you, Mr. President.
Thank you, Senator Pearl. The bill is now on second reading. Is there any discussion? Seeing none, the question is on adoption of the committee recommendation of ought to pass on Senate Bill 329. Are you ready for the question? All in favor, please say aye. Aye. Any opposed? The ayes have it. The motion of ought to pass is adopted. Senate Bill 329 is ordered to third reading. The Senate will please be attentive to the clerk.
Thank you, Mr. President. The Committee on Energy and Natural Resources, to which was referred Senate Bill 346FN, an act prohibiting the use of dogs while hunting coyotes. Having considered the same, the committee recommends that the bill is inexpedient to legislate by a vote of 3-1. Senator Avard for the committee.
Senator Avard.
Thank you, Mr. President. I move SB 346 inexpedient to legislate. This bill aims to prohibit the use of dogs in coyote hunting. However, the committee heard testimony that the absence of hound runners would have a negative impact on the agricultural industry. Currently, coyote hunting with hounds is not common practice and only occurs on agricultural land where coyotes are causing injury or even death to livestock and domestic animals. For this reason, managing coyote population is extremely important, and other methods have proven to be ineffective. If SB 346 were to become law, it would make New Hampshire the only state in the surrounding area to prohibit coyote hunting with hounds. The Energy and the Natural Resource Committee asks for your support in the motion of inexpedient to legislate on SB 346. Thank you, Mr. President.
Thank you, Senator Avard. The motion is inexpedient to legislate. Senator Waters.
Thank you, Mr. President. I rise in opposition to the motion of inexpedient to legislate. This bill would prohibit coyote hounding, and let me note that you can hunt coyotes every which way. And also there is no season on coyote hunting, so even when they have their pups, they can be hunted. The only existing restriction is night hunting. So why was this brought forward? Just to tell you a little bit about what coyote hounding is. It's when a pack of dogs is set after coyote, and they have GPS location on their collars, and they give chase, and the runner of the pack may be on foot behind him, but oftentimes is in a car because they travel some distance. And why do they travel some distance? Because it is quite a chase. Coyotes, unlike some other animals, cannot be treed. So they're going to run till exhaustion, and when they have to turn then on their pursuers, then the dogfight ensues, or when the person who's running the pack shows up, then they can shoot the coyotes. So that's what it is. And I think that over time we have recognized that hounding is something that's not exactly a fair chase, and perhaps does visit cruelty on the animal that is being hounded. We previously prohibited the hounding of deer. And this is within historical memory, and I would say it's because Senator Methuselah remembers when we prohibited this practice. And so for me, the primary reason for bringing this forward was because of the dogs. It's because of the dogs, and feeling that this was a practice that essentially sets up a dogfight, because coyotes, after all, are canids, right? So they are like dogs are canids, and so when this moment of encounter occurs, it is a dogfight. And I think we all would look upon abhorrence with legal dogfights in this state. And what we have done to prevent cruelty against dogs in this state. The governor has set up the governor's commission on the prevention of cruelty to animals. Our Senate president has been just a stalwart for years and years and years trying to protect dogs in this state from cruelty, and I think there are many who believe that this is a form of cruelty to the dogs themselves. And after all, the advice given to people who are going to hound coyotes is there's a extensive thing about bringing your first aid with you, be ready to treat these kinds of injuries. Now, we did have testimony from someone who hounds coyotes, and these people love their dogs. I'm not saying that it's a form of cruelty. They do love their dogs. We get that, and we did hear some testimony that there are, because they are predation some on farms. We did hear about that. Yet we did hear from the state biologist, the wildlife biologist, that coyotes are peripatetic. And that if you do, in fact, hound one out and kill it, another one is going to show up, and so you would be doing it again. We also heard from farmers. We have letters from farmers saying, yeah, we know coyotes are a problem. I have my dogs, and we do our best to keep the coyotes off the property, but they were willing to suffer what losses they may suffer because they found abhorrent the idea of hounding coyotes. So I understand why some farmers want to do it, but I'm not sure from the state biologist's, wildlife biologist's testimony that it really is effective. So this brings me back to the dogs. And other states are now looking at limiting this, either limiting the pack size or limiting the number of licenses that are issued. And I think, like with the deer hounding, this is the direction that we are going. So that's why we brought the bill. Those are the arguments that we heard, and I do think that we ought to ban this practice. Thank you, Mr. President.
Thank you, Senator Waters. Senator Carson. Senator Carson has moved to table Senate Bill 346. It's non-debatable. All in favor of the motion to table, please say aye. Aye. Any opposed? No. The ayes have it. Senate Bill 346 is laid on the table. All right, so in the good news department, the food is here, but I think it's only been here for a few minutes. I don't anticipate any more debates, so if we can just move on through, that would be great. The Senate will please be attentive to the clerk.
Thank you, Mr. President. The Committee on Energy and Natural Resources, to which was referred Senate Bill 450, an act relative to duties of the Grid Modernization Advisory Group. Having considered the same, the committee recommends that the bill be referred to interim study by a vote of 4-0. Senator Waters for the committee.
Senator Waters.
Thank you, Mr. President. I move Senate Bill 450 for interim study. While acknowledging the importance of upgrading our transmission infrastructure, concerns have been raised about the current responsibilities of the Grid Modernization Advisory Group, which we established just last year. Their existing duties, coupled with the tight timeline, pose challenges to undertaking this additional task. The Department of Energy recommends a more thorough examination through a study committee, allowing for a comprehensive exploration of transmission issues without disrupting the ongoing work of Grid Modernization Advisory Group. And I will say that it looks like there's a bill in the House coming to us that is going to help out in this regard. In light of these concerns, the Energy and Natural Resources Committee acknowledges the need for more extensive deliberation and careful consideration of the best path forward. The Energy and Natural Resources Committee asks for your support to move SB 450 for interim study. Thank you, Mr. President.
Senator Waters, I've never heard you speak so quickly. The motion is referred to interim study. Is there any discussion? Seeing no more, are you ready for the question? All in favor, please say aye. Aye. Any opposed? The ayes have it. The motion of refer for interim study is adopted. The Senate will please be attentive to the clerk.
Thank you, Mr. President. The Committee on Energy and Natural Resources, to which was referred Senate Bill 492, an act relative to wastewater engineering, having considered the same, the committee recommends that the bill is ought to pass with an amendment by a vote of 4-0. Senator Waters for the committee.
Senator Waters.
Thank you, Mr. President. I move Senate Bill 492 FN ought to pass with amendment. This bill addresses crucial issues in wastewater infrastructure and the state aid grant program. The proposed change in terminology ensures that all sewers qualify for state aid grants, maintaining clarity in funding partnerships. Representatives from the Department of Environmental Services emphasize the importance of simplifying sewer project terms. The bill also addresses the outdated wastewater operator certification fee, adapting it to cover program costs and training center maintenance. Therefore, the committee amendment changes the certified fee from $50 to $100 and alters language to reflect that the certificate committee is responsible for issuing certificates. The Energy and Natural Resources Committee seeks your support for the motion of ought to pass with amendment for SB 492 FN. Thank you, Mr. President.
Thank you, Senator Waters. The bill is now on second reading. The first order of business is the committee amendment. Is there any discussion? Seeing none, all in favor of the committee amendment, please say aye. Aye. Any opposed? The ayes have it. The question now is on adoption of the committee report of ought to pass as amended. Are you ready for the question? All in favor, please say aye. Aye. Any opposed? The ayes have it. The motion of ought to pass as amended, Senate Bill 492, is ordered to third reading. The Senate will please be attentive to the clerk.
Thank you, Mr. President. The Committee on Energy and Natural Resources, to which was referred Senate Bill 541 FN, an act relative to retail pet stores. Having considered the same, the committee recommends that the bill be referred to interim study by a vote of 4-0. Senator Pearl for the committee.
Senator Pearl.
I move Senate Bill 541 for interim study. While addressing concerns about unlawful animal sales or animal cruelty is important, testimony from the Department of Agriculture raised concern about the bill due to challenges in enforcement, tracking, ownership changes, and potential repercussions for businesses. These aspects warrant deeper scrutiny. Supporters have raised concerns about limiting animal transfers and restricting consumer choice. Those in opposition to this bill cited potential impacts on licensed pet vendors and responsible dog ownership. Given these complexities, the Energy and Natural Resources Committee believes this topic is in need of further review and study. The Energy and Natural Resources Committee asks for your support to move SB 541 for interim study. Thank you, Mr. President.
Thank you, Senator Pearl. The motion is refer for interim study. Is there any further discussion? Seeing none, the question is on adoption of the committee recommendation. Are you ready for the question? All in favor, please say aye. Aye. Any opposed? No. The ayes have it. The motion of refer for interim study is adopted. Moving to the Committee on Finance, the Senate will be attentive to the clerk.
Thank you, Mr. President. The Committee on Finance, to which was referred Senate Bill 134 FN, an act relative to disability pensions for public safety employees who are victims of violence. Having considered the same, the committee recommends that the bill is ought to pass by a vote of 6-0. Senator D'Alessandro for the committee.
Thank you, Mr. President. I move Senate Bill 134 FN ought to pass. This bill, as introduced, creates a new category of disability pensions relating to Group 2 members that are disabled due to a violent injury that is likely to be permanent before attaining normal retirement age. The Senate Finance Committee recommends passage of Senate Bill 134 FN, but I believe the good senator from District 19, the very good senator from District 19, never mind good, let's do it right here, has a floor amendment which makes technical changes to the bill, which will ensure all provisions are clear and consistent regarding implementation and do not conflict with existing law. Thank you, Mr. President.
Thank you, Senator D'Alessandro. I recognize Senator Birdsall, who moves to re-refer to committee.
Yes, Mr. President, and I'd like to speak to my motion. I just want to let everyone know that I am in full support of this, but on Monday I received a call and a visit from Marty Carlin from the New Hampshire retirement system, and he had some concerns, so I'm going to work with him through this month and probably most of next month to try and get something that will not harm the retirement system and help the officers. Thank you, Mr. President.
Senator Birdsall has moved to re-refer Senate Bill 134 back to the committee. The question is on adoption of the recommendation of re-refer. Are you ready for the question? All in favor, please say aye. Aye. Any opposed? The ayes have it. The motion of re-refer to committee is adopted. The Senate will please be attentive to the clerk.
Thank you, Mr. President. The Committee on Finance, to which was referred Senate Bill 248 FN, an act relative to bail for defendant. Having considered the same, the committee recommends that the bill is ought to pass by a vote of 6-0. Senator D'Alessandro for the committee.
Senator D'Alessandro.
Thank you, Mr. President. I move Senate Bill 248 FN ought to pass. This bill amends the statute governing bail and pretrial release to include provisions for pretrial detention for commission of certain offenses that would create a presumption that the defendant is a danger to the public. The Senate Finance Committee recommends passage of Senate Bill 248 FN and asks for your support. Thank you, Mr. President.
Thank you, Senator D'Alessandro. The bill is on second reading. Is there any further discussion? Seeing none, the question is on adoption of the committee recommendation of ought to pass on Senate Bill 248. Are you ready for the question? All in favor, please say aye. Aye. Any opposed? The ayes have it. The motion of ought to pass is adopted. And Senate Bill 248 is ordered to third reading. The Senate will be attentive, please, to the clerk.
Thank you, Mr. President. The Committee on Finance, to which was referred House Bill 307 FN, an act relative to attorney fees and actions under the Right to Know law. Having considered the same, the committee recommends that the bill be referred to interim study by a vote of 4 to 2. Senator Gray for the committee.
Senator Gray.
Move to table.
Senator Gray has moved to table House Bill 307. It's non-debatable. All in favor of tabling 307, please say aye. Aye. Any opposed? No. The ayes have it. And Senate Bill 307 is laid upon the table. The Senate will please be attentive to the clerk.
Thank you, Mr. President. The Committee on Finance, to which was referred House Bill 596 FN, an act prohibiting the use of racial profiling in law enforcement activities and sentencing. Having considered the same, the committee recommends that the bill is ought to pass by a vote of 6-0. Senator Gray for the committee.
Senator Gray.
Thank you, Mr. President. I move House Bill 596 FN ought to pass. This bill defines and prohibits profiling in law enforcement activities and in sentencing. It also requires the Department of Corrections and each county house of corrections to collect and report data on race and ethnicity of defendants sentenced to a term of imprisonment of 1 year or more since 2000. The Senate Finance Committee recommends passage of House Bill 596 FN. However, I am offering a floor amendment 0571S, which changes the beginning date of the annual report from November 1st of 2023 to November 1st of 2024. Thank you, Mr. President.
Thank you, Senator Gray. The bill is on second reading. Is there any further discussion? Senator Gray has introduced Amendment 571S. He has spoken to it. Would he like to speak again?
Not unless somebody has a question. Thank you.
The question is on adoption of the floor amendment that changes the date. Are you ready for the question? All in favor of the floor amendment, please say aye. Aye. Any opposed? The ayes have it. The floor amendment is adopted. The bill is still on second reading, open for further discussion or amendment. Seeing none, are you ready for the question? All in favor of adoption of the motion of ought to pass on House Bill 596, please say aye. Aye. Any opposed? The ayes have it. House Bill 596 is ordered to third reading. I recognize Senator Carson for a motion.
I'm sorry, Mr. President. I've got multiple papers. Thank you, Mr. President. I move that the Senate adjourn from the early session, that the business of the late session be in order at the present time, that all bills and resolutions ordered to a third reading be, by this resolution, read a third time, all titles be the same as adopted, and that they be passed at the present time.
All in favor, please say aye. Aye. Any opposed? The ayes have it. The early session is adjourned. We are now in the late session. Any brief announcements? Senator Rosenwald.
President, we've spent much of the day talking about pregnancy, and I would just like to say that my daughter is pregnant, and I'm going to be a grandmother again. So, thank you.
Mr. President, I want to just make a quick announcement. Today is a very glorious day for the Horgan family. Jenny Horgan is having a birthday. None better than the beautiful Jenny Horgan. Nothing better. Woo! Thank you, Mr. President.
Senator Ricciardi.
I know it's been a really long day, but we lost very good friends of ours. Father passed away on February 11th. We've been friends for close to 50 years. And today was the wake, the funeral, and the meal to honor his memory. And I had a Senate duties call, so I couldn't be there. I asked my husband to represent our family, but I would be remiss if I didn't honor his memory. His name was Donald Wellesley Flood, so keep the family in your thoughts. Thank you.
Thank you, Senator Ricciardi. Seeing no other personal privileges. Senator Prentiss.
Thank you, Mr. President. Unanimous consent. Very brief. I'm actually going to hold until the Honorable Sharon Norgren's family is going to be coming to the State House, where she'll be honored by the House, and I'd like to coordinate so that my comments regarding someone who many of you served with, an 18-term legislator who passed away this weekend from Hanover, I will reserve them to when her family's here. I just couldn't let the day go by without mentioning this. Thank you.
Any further personal privileges? Just looking ahead to next week, the calendar will be out soon. This is a draft calendar. There are 35 bills. I think 21 are on consent and 14 are on the regular calendar. 7 of the 14 have split votes, so there could be a few debates, but I think that we will easily finish the calendar on Wednesday at a timely hour, even though we'll be starting at 1. And Senator Soucy, you will be happy, okay? So, without objection, all personal privileges or unanimous consent or other remarks shall be entered into the permanent journal of the Senate per Rule 216 and 217. Seeing no further business, I recognize Senator Carson for a motion.
Thank you, Mr. President. I move that the business of the day being completed, that the Senate recess to the call of the chair for the purposes of introducing legislation, re-referring bills to committee, scheduling hearings, sending and receiving messages, vacating bills, and processing enrolled bill reports and amendments. And when we recess to the call of the chair.
All in favor, please say aye. Aye. Any opposed? The ayes have it. The Senate is in recess. There is food in room 100, and we're in recess to the call of the chair.